The list for judgment, Dr. 13 of 1995.
Well,
I'm for the petition number.
I'm waiting for the
Start
response.
today's work with permission of my brother. We would like to actually say something. From tomorrow, we will not list the hearing matters. It will only be motion court matters because
My lord, I missed 1 week.
if yes, you missed a week, I know. Is everything fine at your home now?
No.
I know we love to do it because we will have just a few more days. It will be difficult to reserve judgments and pronounce them. So we'll take up all short matters and try to dispose of as many as we can.
My lord, my lord. Right?
We have allowed the application in part. This court is inclined to hold that the order impugned insofar as the order passed by the appellate authority on June 13, 2022 is affirmed by the tribunal is required to be quashed or set aside. The appellate forum is a wrong forum chosen. So that part is being set aside. So only that portion of the order which has affirmed the appeal is being set aside. Liberty is granted to the petitioner to assail the order passed by the disciplinary authority on May 1, 2021, before the appellate authority authorized to deal with the appeal in terms of Rule 9.1 of the policeman.
Well,
Even the petitioner prefers such appeal, the appellate authority shall deal with the same on merits upon condoning the delay in preferring the same, because there is a delay question, as expeditiously as possible upon granting reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law.
well,
Okay.
No, not hearing that list. Please show me the draft list before you issue. Before it is finally. Please show me the list. Yes, next.
Item number 2, SCT 7 of 1995.
It's my second appeal, madam. This, before I think, order passed by on one consent party of, Calcutta as well as.
Is this for admission? Why is it appearing as a motion? New motion? New motion is still.
no compiling.
New motion. Oh.
Department report.
Yes, what is the substantial question of law?
My check is made on address today. I have claimed the description on the basis of, I have the plaintiff applying this matter. I have claimed the description on the basis of legal duty, so equal and fair response to this matter in their 1911. Subsequently, the matter was filed. I have filed that this suit in the year 1950. Until that time, I was never disturbed. My position was continuous. I never filed any suit for recovery of the position. So I came before the trial court for claiming my right on the basis of.
What is the question of law involved, madam?
The question.
You're talking about factual aspects.
Page 13.
Can to be in permissive possession of the property. It's a law that a permissive possession cannot be converted into an adverse point and report that property concerning possession started and adverse tax feasible.
Consider the date which I specified in my prior court, that is the date for adverse possession. They have not advertised.
And in the first appeal?
The first in trial court, they have not considered that exhibit also.
What about the first appeal?
In first appeal, they have stated it cannot, without giving any explanation, they have stated it cannot be repeated as the date for the claimant adversary. Without giving any explanation for that.
The questions that have been framed by you are all on facts. The second appeal cannot lie on facts, madam. If you want to take instructions and come back, you can. I do not find any substantial question of law to be decided in the second appeal. Let it be before the next circuit. Please take instructions. Learned counsel for the appellant seeks to take necessary instructions on her prayer, the matter be placed before the next available circuit bench. Please take instructions. We do not find any substantial question of it. We could have dismissed it, but then you can find out.
Item number 3. 7026 of.
In this matter, I appeal for the petition, my lord.
Yes.
Application for restoration of memorandum of appeal. Let the order was passed and it was dismissed by default.
The appeal.
Yes. Annexure P1.
One.
And page number 10 and 11 maybe kindly.
All the respondents are served.
Industries.
This one. Service has been also
Private
completed.
respondents are there. I appear on behalf of respondent 165.
Correspond number 7.
689.
Can. Within time?
Yes.
Yes, I don't think you'll object to the restoration. You have not included all the parties?
Yes,
Between the private respondent and the.
all the party has been added and the service also been filed.
There were 9 respondents in the original title. And in this, isn't there only?
You have not included the private respondents? Yes, you have, but whom have you deleted then? 9 respondents in the appeal, and in the application there are 5 respondents, 7 respondents. Why? Who are the 2 respondents that you've chosen not to include?
But from the notice about respondents.
Please see the cause title of the application, Can 1 of 2025.
5, 6, 7.
Deleted Director of Industries and State Property Land.
Why? Yes,
Actually,
Private respondents have been added,
but the original 6 and 7 are not there.
the forwarding.
No, I will
it's
file
not
amended.
received, but it's 9 respondents. The forward.
We'll allow you to amend the application, you have to serve them.
I have served but not added there.
Where is the service, the affidavit of service?
That is also been filed.
It was service which we have. Directorate of Industries, the one for cooperative bank. 6 and 7 in the main application. Directorate of Industries and the Cooperative Bank. Served. Served and the Cooperative Bank.
Yes.
Served. On prayer of the petitioners, liberty is granted to incorporate the names of respondent numbers 6 and 7 recorded in the application being MAT 26 of 2025 by amending the cause title of the present application. The said respondents are not represented despite.
Actually, I appeared with respondent number 6.
So let us not record this in that case. Restoration application, let it be restored,
I
fight
will
it
appear,
out
I
on
will-
merits.
No, I'm not objecting, but
Forwarding
my,
letter.
my appearance to the extent of respondent 6 may be recorded.
He is not happy.
Yes,
But-
delete that line. No, the last line. I said not represented. Delete that. Paragraph, heard learned counsels for the parties. The petitioners seek restoration of MAT 26 of 2025, which was dismissed for default by an order passed on June 10, 2025. Paragraph, sufficient grounds being laid out, comma, the application being can 1 of 2025 is allowed. The order dated June 10, 2025 is set aside. Paragraph, sir. Paragraph, MAT 26 of 2025 is restored to its original file and number. Do you want to come back with affidavits in this matter? Then we'll direct so. Not required.
File a paper book. Paper book is equal to.
Yes.
No, maybe it has not been executed. I think so. It was dismissed before.
Oh, it was at the admission stage. Yes, right, you're right. What is the order that is challenged? Single bench order, right? 12th March 2025.
Just a minute.
The appeal has to be admitted after the direction for filing paper.
Yes, we'll do that, but let that be done today itself. That saves a day, right? Or you want us to fix it for admission of appeal again?
Because today, my lord, all the parties will claim before minutes. Because private respondents, because this is your main.
Paragraph matter be placed before the next available circuit bench. You'll get some breathing time. The matter be placed before the next available.
Right.
Next.
Item number 4, taking it 12 and 25.
Service is incomplete here also.
Service is incomplete here. Since service upon the respondents is not complete, comma, the matter be placed before the next available circuit.
Your worship. Interim order, your worship.
Is there
I
already
remember it was there.
till?
When it is. When it is, I think it is up to 31st August,
So the circuit starts before.
25th year. Okay.
Not necessarily. But it's supposed to be.
Item number 5, SAP 4 of 2025.
If my elder sister seriously not opposing, can I have this matter in the next circuit? Because I'm not feeling that. Lord, she seriously opposed, then I will place. I'm ready.
She's not. She has a smiling face. She's not seriously opposing.
I'm ready. I'm trying to.
On prayer of the appellant, the matter will be placed before the next available circuit.
Item number 6. Payment to 2025.
Yes, appellant.
Well, I am appealing for the respondent. If my learned friend can serve a copy of what
I serve a notice because it's not in middle and the month. So I give a copy, my lord. I give a copy to.
You only served a notice.
Yes, yes, because earlier I sent the speed post, but it is nobody has appeared, then this court directed me to issue a notice. Subsequently, I issued a notice.
we have recently known it's a we are appealing. Last petition, my junior has filed for cover conflict.
I just make a copy and give.
It's a short matter, it can be taken up tomorrow also, very short. And even I think there would be delay.
Where is your section 5 in that case?
My lord.
There's a delay.
Yes, yes, my lord. We have
There
not
ought to be a delay, this long back, this.
This is section 5.
Oh, this is the section 5.
Lord,
So let us allow the section 5 at least. We can go a step forward.
किसका है? कल्पना होल्डर का देखो नहीं.
How many days? 80 days delay.
87.
80 days. 87. Because my lord, the date of correction order from the date of correction
No,
of the
no,
order.
parent order was passed,
In
no, no,
2023,
one
my lord, because there are a correction of the date.
parent order was passed in 2023. I
The
think.
amendment says 87 days delay.
No,
Right.
it's- Can't be, my lord, because
My lord, one case is 87 days. That's right, my lord, because.
This is the
You know, the Sanka channel.
256. Oh, no. कौन सा दिन है?
Mat 29.
Mat 29.
भैया मैट 29 ठीक है. इसका मैट 29 122. देखो
December का order है।
हाँ, तो
कौन चीज?
मार्च में कर दिया है.
Mat 29.
चलो मतलब वो हाँ, not this 80, that delay is correct.
दूसरा वाला?
It's recorded as 84.
87 days.
It's recorded as 87 days.
87 days.
Let it be allowed, my lord. दूसरा ये नहीं,
Can
पहले
be.
वाला but थोड़ी correction जो है
हाँ?
December 2023.
Appellant seeks condonation of delay in preferring the appeal. Paragraph heard learned counsels for the parties. Paragraph sufficient grounds being laid out, comma. The delay in preferring the appeal is condoned. Can 1 of 2025 is allowed.
इससे तो जाएगा.
Paragraph the appeal be placed
अभी तो
before the next
ठीक है,
available
right.
circuit bench.
तो अपील.
Please serve a copy in the.
Yes, yes, ma'am.
Next.
Section 7, match.
It's a similar matter, but here, my lord, the parent order was passed on 21st of December 2023.
But thereafter,
Here I have objection, my lord. How it can be?
I just clarify, my lord. Thereafter, my lord, what has happened? They claim for the salary from May 2020 to October 2020. But
Claimed for?
salary of arrears of salary from May 2020 to October 2020. But subsequently, they found that the order which is passed by this honorable court was error has been occurred. So subsequently, a correction order has come into place, and which
When
is
is that order?
18
Correction order.
18 November 2024, my lord.
Only
Ah.
year was corrected.
After a year, they come for correction of that order.
This,
This order I can see from the, my lord, I appeared before the trial court.
find it
First.
out on merits.
My lord.
I'll record your objection, find it
Well.
on merits. Can 1 of 2025. The appellant seeks condonation of delay in preferring the.
It is.
Here also it is 80 days.
Date of the correction order, it is 80 days. ma'am.
From that date
Yes, yes, madam.
of delay in preferring the appeal. Paragraph heard learned counsels for the parties. Paragraph learned counsel for the respondent.
Respondent, sole respondent.
Yes, respondent raises objection to the application. Paragraph, sufficient grounds being made out by the appellant, comma. The delay in preferring the appeal is condoned. Paragraph, can 1 of 2025 is allowed. Paragraph, the appeal be placed before the next available circuit.
Oblige, ma'am. Huh?
புரியல காப்பி எனக்கு கொடுக்கறதுக்கு ஆர்டர் பண்ணணும்.
பண்ணிடுறேன், நான் கொடுத்துறேன்.
Next.
Item number 8, immediate 38 of 2025.
Even these, I requested my younger sister. She, with the same smiling face, she also said that she had no problem.
What is this about? It's not a short matter.
Oh, this can be, not let it come tomorrow, I'll move this one. Let it come tomorrow. It's a very short only. I'll come. This can be.
My lord, the appeal has to be admitted in both the matters, then paperwork direction has.
Yes.
that is some-
It's even that can be.
So let us admit the appeal. Alternate counsels for the parties. The appeal has been preferred. Which is the order against which the appeal is?
It's an order dated 8/2025.
It's a pending issue.
It's a pending, it is pending.
No, my lord, the.
What is the issue?
No, what has happened?
Order.
It's an order passed, yes,
Yes, order has been passed.
for inspection.
By a special officer of this school.
Yes,
To that extent, I have no problem.
yes.
But the writ code have directed the Tahsildar to assist the special officer is, which is creating a problem, because before the writ code, the order of the Tahsildar is under challenge, wherein I have been held to be an encroacher of this survey number 1069. To that extent, I am prejudiced in this claim. Independent inspection by special officer, I have no problem. But with the aid and assistance of Tahsildar concerned, because that the very ground of challenge would go, Lord.
We really don't think so.
No.
When there is a
Survey-
dispute, both the parties to the dispute need to be present when the inspection is done.
And
In as much as the petitioner's, the appellant's presence is, the petitioner's presence is required, the Tahsildar's presence is also required.
Presence, I understand, but Mother to see the pen and given paragraph,
Survey
necessary,
lord.
render necessary assist
Render
to
necessary.
when a special officer. The Tahsildar would assist the special officer, my lordship, with the records based on which an order has been passed, which is subject matter of the
Shall
petition.
render necessary assistance,
My
but
lord.
it is not stated with the records and all that.
These have, the Tahsildar would do only this thing, my lordship, just to not, my entire ground would go.
We do not find any ground for appeal.
In the second time.
We need to dismiss this. I cannot be admitted. Cannot be admitted.
Then
This is a very innocuous-
Then this can be done tomorrow also, my lord. What is falling from
The-
my lord, tomorrow I
the
get
earlier-
myself prepared.
The earlier the better.
My lord, it's a matter of one day, I will come back prepared tomorrow. my lord.
Doesn't like.
I'll come back.
We can allow you to withdraw at best.
No, let order needs to be passed, because what happened, Lord, so ultimately, the special officer submits a report. And I have challenged one order of the Tahsildar, but that would be causing prejudice to the Lordship. If a report comes and particularly the Tahsildar concerned would render the special officer with the records, because it is obvious, Lord, the Tahsildar would pay.
Have
the
you
same
challenged the records?
No.
Have you challenged the records?
Everything has been challenged before the writ court, Lordship, including the very decision making process.
Please show us a line that you've challenged the records.
The decision making process of the Tahsildar is under challenge.
Decision-making process may be under challenge.
Yes.
That has to be done in a writ petition.
Lord,
But you cannot challenge the records in a writ
I
petition,
challenge
right?
it. Taking specific stand, I can show you not.
How can you challenge the records in a
Because
writ?
records, based on records, reports were called for. Based on reports.
Well, please come back tomorrow. We'll clear it out tomorrow.
No.
Because prima facie, we say that there is no problem.
I have a right to persuade my lord, I have a persuade my lord. I have a right to persuade my lord.
On prayer of the appellant, the matter is adjourned for the hearing.
Conducted by the
Item 9, plan 39 of 2025.
assistant of survey to market whether any enforcement is.
So there is application under order 41 rule 27 coming up along with this appeal. It will take time. It has been filed. So let this appeal be taken up in the next.
You filed the
Yes,
application?
additional documents, the documents which was not before the report when the order was passed. As regards the factum of filing of the suit, as regards factum of an injunction order being granted by.
And you are aware of those documents when the,
After the report passes an order, suit was filed. In the suit, every facts were treated as regards the order being passed by the writ court. This needs to be brought in lordship. Otherwise, the justice of the appeal cannot be done.
Are you objecting to the application?
It's not been listed, no, it's not been listed.
Oh.
So let this be
Even
taken.
the copy of appeal has not been supplied to them.
Has the appeal been admitted? No.
No.
Nothing has been done.
Has not been admitted.
On prayer of the appellant, the matter be placed before the next available assembly.
Bill number 10,
Actually,
24.
my lord, I am for the appellant. My lord, I am seeking extension of time to file the additional paper book, my lord. I am unable to file today. Not ready, my lord.
Seeks extension of time to prepare the paper books,
Supplementary paper.
the supplementary paper books. Paragraph, the matter be placed before the next available circuit.
Obliged, my lord.
Please serve in the meantime, get it ready and serve
Yes,
so
ma'am.
that it can be taken up
I-
in the next.
Yes, sure.
Item number 11,
Obliged.
29 of 924.
Lord, I'm for the appellant, my lord. So far as I have checked the lower court requirements, there is no undertaking was given by the appellant to deposit the amount. Only the undertaking was given by the appellant before the executing court for depositing the money. Only the court had directed to furnish the assets and liabilities. That is fixed for that. The last order, yeah.
You are the petitioner, the appellant.
The last paragraph.
Yes, have you deposited this?
Lord, that is the last order I have checked it. It is list of assets and liabilities.
30th January 2025. The awarded sum shall be deposited in the court by the next date, that is ID next course of course of action. shall- Not deposited.
Not deposit.
Lord, I,
How early can you deposit? Please comply with this order, otherwise the law takes its own course.
Thereafter,
But it-
the court passed the last order. and-
Lord, 6 weeks time may be granted, my lord,
To deposit them.
because this is a 30 to 40 lakh.
Last order by the.
Last order,
Assets and liabilities has to be some.
that bank details, so since they have not deposited, bank details so has to be furnished.
This is on 16th July.
हाँ ये ऑर्डर
There was also a direction for affidavits in this matter, I find. There's a direction for affidavits in this matter.
Affidavit of filing.
assets and liabilities. For
Yeah,
affidavit to file assets and liabilities.
Opposition.
Uh-huh.
Stay application.
Yes, yes, he has filed, he has filed. He has filed
I
the
filed
affidavit
the
of opposition.
opposition, reply was
Reply has
to be
also
filed by
been-
them.
Reply has not
You
required.
find the reply.
No, no, it is, their only contention was the stay along with the appeal has to heard together. That was the only reply in the, against the stay application.
Apparently, the execution case
Right.
is pending and you need to comply with the orders
Lord,
of the
what
court.
I, subject to my lord's kind consideration, Lord, what I suggest, my lord, let a date be fixed for deposit the award secured award amount in terms of the,
This court will not deal with that because the executive court is already dealing with this. There cannot be parallel proceedings. Please comply with the executing court's order.
Will there be direction to close on this bulldozer?
The appellant seeks extension of time to use the affidavit in reply to the affidavit in opposition used by the respondent in respect of the stay application. Paragraph, learned counsel for the respondent produces copies of orders passed by the learned executing court in money execution number 9 of 2019, which demonstrate that on 16th July 2025, the judgment debtor / appellant herein on 30th January 2025, the date as stated wrong. On 30th January 2025, the judgment debtor / appellant therein undertook to deposit the awarded sum before the learned executing court by 28th February 2025. Stop. It is not in dispute that the said amount has not been deposited till date. Paragraph, learned counsel for the appellant seeks accommodation to deposit the said amount before the learned executing court. In view of the above, comma, the matter is
Is
adjourned.
there a time frame?
It's stated that law will take its due course. So it is at his risk and peril now.
Is there be
Yes,
direction for paper book?
But it's better.
we will
What
file
I
it.
suppose related direction will given for paper book so that in the meantime appeal.
Let the other bench deal with it because
Yes,
the
yes,
appeal
yes.
may not be admitted.
Yes, yes.
It is
If I
only
are not
if it's
depositing them.
admitted that paper books will be called for. We are not going into that now. Let him deposit the amount first.
Yes.
In view of the paragraph, the matter be placed before the next available sir.
So, Blair.
Next.
Item number 12, WC 39/24.
I'm appearing for the respondent, madam.
Humble submission if this matter can be taken up to the next session.
Let it be at their request, no difficulty.
On prayer of the petitioner, comma, the matter be placed before the next available sir.
Item number 30, here Division of 125.
The respondent also states the criminal appeal against the conviction order under POCSO.
Who is appearing for the
Your Honor, my senior, your lordship, my senior is appearing for the petitioner.
appellant? Yes.
Appellant is not keeping well, praying for next circuit.
On prayer of the appellant, the matter be placed before the next available sir.
Item number 40, WPCT of
I'm appearing for the respondent, my lord.
I am appearing for the petitioner, my lord.
The hearing matter, I think it will take some time, but subject to what Mr. Kumar feels.
Learned Council, Union Government to file an affidavit and time to time extension was accorded to them.
Are you ready with that?
No, my learned friend is not appearing for Union Government. He is
I
appearing
have filed my, we have filed our affidavit. Union of India, I think I required.
for the Union of India.
I am appearing for respondent 3 to 6. Our opposition is already on, we have filed our opposition.
It was extended by 2 weeks on the earlier.
My lord.
Yes, for Union of India.
My lord.
Where is Mr. Lal?
So let me take on Thursday. He has come today. He come for Thursday.
Where is the affidavit in opposition?
Let him. Oh my God.
Yes,
Time to time extension was given, my lord.
please file the opposition at least. They have
Yes.
back with the
Yes,
reply
Thursday.
after that.
Thursday.
Right? Thursday you'll file the opposition, right? The Union of India seeks further extension of time to use the affidavit in opposition as sought. Paragraph. Let the matter appear. Let it appear as to be mentioned because we'll not be taking care of hearing matters. Let the affidavit come on board
I'm good.
under the heading to be mentioned. On 7th August. Next.
number 50,
15 also, my lord, I am appearing for the respondent, my lord. This is required to be heard. my lord.
Can be taken up, my lord. The issue is, my lord, this petitioner was appointed as a constable on 15th of July 2002 under the Andaman Nicobar Police. My lord, he was promoted to the post of head constable on 22nd of June 2016. Now, my lord, subsequently, during the year 2017, he remained absent for some day, and the authorities initiated a proceeding and passed an order whereby his future increment for a year was stalled, my lord. Unauthorized absence. Subsequently, my lord, again in the year 2020, a proceeding was initiated wherein it was contended that he was absent from December 2017 to November 2018, and therefore in the proceeding he admitted his guilt that he has not appeared. They imposed a penalty whereby they said that no work, no wages, loss of pay. Now, my lord, this time, both the occasions, such unauthorized absence was regularized by the authorities. Now, this is not the subject matter of challenge. What happened, my lord, while he was posted, my lord, on 24th of April 2023, absentee notice was issued upon him that from 17th of April 2023 he is absent. Now, my lord, after issuance of an absentee notice, subsequently, my lord, they issued a desertion notice by invoking the provision of 6.19 of the police manual and subsequently confirmed the same, whereby I have been dismissed from service. The only question which is to be adjudicated, whether on the basis of a subdelegative legislature, a person can be thrown out of service by violating the constitutional right under Article 311 of the Constitution of India or not. This is the only issue, my lord. And this same issue earlier cropped up before this honorable court, where when same order was passed, similar order was passed by the tribunal. I challenged it before this court, and I have cited the authority of law on this, my lord. And this court allowed my writ petition and directed them to impose some minor punishment. They challenged it before the Supreme Court. Supreme Court dismissed at the admission stage. So I will place, my lord, the documents. My lord, may kindly come to page 89, because these two aspects, my lord, may kindly have a note of it. In 2017 and 2020, they have regularized the set period, my lord. So it doesn't remain unauthorized absence. Kindly have a note of this, my lord. Now, my lord, may kindly come to page 89.
What are the earlier periods? Please repeat once.
My lord, those orders I have enclosed, my lord.
Well,
My lord, will get it at page 57, my lord. The absentee notice, thereafter a memorandum at page 60, and the order, my lord, at page 64. This is for the period 2017 when he was absent for 10-15 days, whatever, my lord. And second order, my lord, this is the first order, my
are
lord.
you referring to the paper book?
Paper book, my lord. Or, my lord, I will place those two orders. I will just give the reference. Page 64 is the first order, my lord.
Yes.
This is the first order, my lord. Punishment operative portion is, my lord, at page 65, last paragraph.
So this is 7/7/2017 to 24/8/2017. This period was regularized.
My lord.
Yes.
49 days, my lord. That they say loss of pay, my lord.
Yes.
Now, my lord, the second order, that is at page 72. Relevant would be, my lord, page 73, before the tabular form, last paragraph. Therefore, in view of.
Yes.
Now, my lord, these are the two earlier order. Now, my lord, may kindly come to page 89. And in both the occasion, that period was regularized. There also 6.19 was invoked. Now, my lord, may kindly come to page 89. I'm sorry, my lord, there are several pagination. My lord, page 113 or 89, my lord, both are paper book. आप लोग बनाओ.
Yes, there are two now resolutions.
ये हम लोग ने बनाया. You have prepared this.
113, yes.
113. Absentee notice, my lord. HC so and so posted at PS Aberdeen was detailed for day High Court HC duty at police station Aberdeen on 14/4/2023 from 8 AM to 20 hours. But he was found absent from his duty from the afternoon of 14/4/2023 without any intimation. Got it, man?
Yes, yes, I got it.
Yes. Without any intimation. In this regard, his absent report has been made in the GD entry Aberdeen on 14/4. Till date, he has neither reported back
This
for.
has nothing to do with the earlier dates. This is a subsequent date.
No, my
altogether.
lord, because the tribunal has taken into consideration that earlier also he was unauthorized absent. No, my lord, that unauthorized absent was regularized by the
He
authorities.
was unauthorizedly absent.
Absent.
No dispute.
Yes,
That was subsequently regularized.
regularized. Absolutely, my lord. I vote on, my lord.
Was unauthorized.
I vote on, my lord. That was regularized. But the tribunal has taken into consideration that he was unauthorized. Therefore, it cannot be. My lord.
Every time there is an unauthorized absence which is regularized, that doesn't give him the liberty to have
No,
go
no,
into an unauthorized absence.
absolutely not. Absolutely not,
It's
my
the
lord.
third instance.
Third instance, but my lord, what we are on, that 311, if a government servant do any misconduct, then a regular disciplinary proceeding ought to be taken place. I am on that, my lord. Here, this time, there was no disciplinary proceeding, my lord. Now, my lord, may kindly see, directed to report duty. So the allegation is that from 14th April to 24th April, he was absent, my lord. Now, my lord, may kindly come to page 77. This is the invocation of rule 6.19. May
Desertion.
12th May 2023. Now, my lord, may kindly have, I just read it out.
Yes.
It says, my lord, head constable so-and-so posted was deployed for a day duty at so-and-so, but he was found absent from his duty after the afternoon of so-and-so without any intimation, permission of the competent authority. In this regard, his absent report has been made in GD entry number so-and-so. Now, my lord, from here, subsequently an absentee notice dated 24/4/2023 has been issued to him with the direction to report for duty immediately at his place of posting, failing which he will be declared as a deserted after completion of 21 days. Continuous service. Till date, neither he has reported for duty at his place of posting nor submitted his intimation application to the competent authority. Since his unauthorized absence from duty has exceeded more than 21 days, he is declared as a deserted under Rule 6.19 manual and his name is struck off from the roll of Andaman Nicobar Police. Under Rule 6.19b, Binoy is further given an opportunity to appear before the undersigned along with his explanation for reinstatement within 2 months from the date of commencement of his absence. Now, my lord, this is issued on 12th May. The 2 month ought to be from 12th May onwards. It says within 2 months from the date of commencement of his absence, dated 14/4, failing which desertion order will be made absolute. Now, my lord, next page is the confirmation of desertion. So, my lord, by this order, my name was struck down from the Andaman Nicobar Police. Now, my lord, may kindly come to the order dated 15 June 2023. Next page, my lord.
Yes.
This says, my lord, at subsequent unauthorized absence from so-and-so, subsequently since his next paragraph, my lord, since his unauthorized absence from duty exceeded more than 10, he was declared as deserted and his name was struck off from the roll of so-and-so. Page 54, my lord, the very next page, my lord. Dated 15th of June 2023.
Yes.
First paragraph is the replica, my lord, what has been stated. Second paragraph. Since his unauthorized absence from duty has exceeded more than 21 days, he was declared as a deserted under rule so-and-so and his name was struck down by the order dated 12th May so-and-so. Further, as per rule 6.19, he has been given an opportunity to appear before the undersigned along with his explanation for reinstatement in service within 2 months from the date of commencement of his absence, failing which the desertion order will be made absolute and his name will finally be removed from the roll of so-and-so. The copy of the desertion order was served upon him on so-and-so, but till date he has failed to appear before the undersigned for reinstatement in service. Now 2 months of his unauthorized absence without leave got completed. Hence, in exercise of the power under so and so desertion, P. Binoy is hereby confirmed and his name is finally removed from the roll of Andaman Nicobar Police. Now, my lord, my argument is, my lord, if I am a regular government servant, by invoking the rule, you without conducting a disciplinary proceeding, you cannot throw me out of service, my lord. Now, my lord, may kindly see 6.19, my lord, of the police manual.
Policeman. Six.
Six point 19.
Yes, this has been followed.
This has been followed. Now, I say, my lord, this is contrary to Article 311 of the Constitution of India, my lord. Now, my lord, may kindly come to Article 311, my lord.
Constitution. Yes.
It says dismissal, removal, or reduction in rank of a person employed in civil capacity under the union or a state. No person who is a member of a civil service of the union or an all India service or a civil servant of a state or hold a civil post under the union or state shall be dismissed or removed by an authority subordinate to each by which he was appointed. No such person as aforesaid shall be dismissed or removed or reduced in rank except after the inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Provided that where there is proposed after such inquiry to impose, that will not come, my lord. Provided further that this clause shall not apply, my lord. That is B. Where a person is dismissed or removed or reduced on the ground of conduct which has led to his conviction on a criminal charges, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practical to hold such inquiry. Where the president or governor, as the case may be, satisfied that the interest of security of the state, it is not expedient to hold such inquiry. If in respect of any such person as aforesaid, a question arises whether so and so, the decision shall be of the authority empowered to dismiss. So, my lord, this is exception to general rule, my lord. And my lord, this being the father of all the law, my lord, Constitution will prevail over the rules which has been promulgated by them. Now, my lord, here, my lord, same similar situation arises before this honorable court. And my lord, may kindly see this judgment, my lord, where this all aspects were taken into account, my lord. I will read the order, my lord, whereby this factual aspect, if my lord sees, were considered. My lord, may kindly come to the first page of the order. This is order dated 11th of June 2024, my lord.
Yes.
The petitioner has challenged the order of the Central Administrative Tribunal, whereby the termination of the petitioner from his service as police constable, which was affirmed by 2 forum, was upheld. Now, my lord, learned counsel for the petitioner argued that although the respondent authorities relied on clause 6.19b of the Andaman Nicobar Police Manual, the authorities failed to give an opportunity of hearing to the petitioner to explain his absence prior to the termination. Secondly, it is argued that the provision of Article 311 2b of the Constitution was overlooked by the respondent authority while doing so. Learned counsel for the petitioner also placed reliance on a judgment in the matter of so and so of the Supreme Court, where the Supreme Court inter alia considered the conferment of permanent status of an employee observed that such status guaranteed security of tenure, and in such cases, irrespective of the provision of the extended rules, an opportunity of hearing and of offering an explanation ought to be given to the accused person. Learned counsel appearing for the respondent authority at the outset submit that merely because another view is possible on the materials on record, this court ought not, in the exercise of its jurisdiction under Article 226 of the Constitution of India, to substitute its own finding for that authority passing the impugned order. That about, since concurrent finding has been written by several forums, those ought not to be set aside. Learned counsel further argued that the provision of clause 6.19 of the 1963 manual are unambiguously clear insofar as the unauthorized absence of an employee is concerned, in which case it has been provided in clause A thereof that the officer's name shall invariably struck down from the date of absence in the case of absence without leave for 21 days, which qualify as an offense of desertion. It is further submitted that in the present case, the petitioner did not avail of any further opportunity under section whereby the desertion is given an opportunity to attend within 2 months from the date of prescribed by the superintendent of police give him explanations. As such, it contended that the decision taken by the respondent to terminate was fully justified under the governing provisions of law. In the present case, my lord, from here, my lord, I invite my lord's attention. In the present case, upon careful perusal of the material on record, we find that the provision of Article 311 of the Constitution of India, which were required to be read into the 1963 manual, were not considered by any of the authorities below. It is well settled that since the Constitution is the ground norms and the source of all law in the country, the provisions of the same override anything contrary thereto in any subordinate legislation. Clause B of this second proviso of Article 311(2) clearly provide that only where the authority is empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practical to hold an inquiry. It would be appropriate for such authority to dismiss or reduce in rank such person without such inquiry. Clause 1 of the said article provide that no person who is a member of so-and-so or All India Service or state or hold a civil post or the state shall be dismissed or removed by the authority subordinate to that by which he was appointed. Subclause 2 of Article 311 provided that no such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and give a reasonable opportunity of being heard in respect of those charges. In the present case, as evident from the notice dated 4th December 2020, the Superintendent of Police apparently given an opportunity to the petitioner to appear before the said authority with his explanation. However, the same has been rightly explained away by the learned counsel for the respondent to the effect that such opportunity was the outcome of an unhappy drafting, since on the date of such notice there was no scope for grant 2 months. Now, my lord, I have shown that portion, my lord, whereby already 1 month was passed when they have issued 12th May 2025, whereby they said the 2-month period. That was not there. Since similar was the situation here, my lord. Since on the date of such notice, there was no scope to grant 2-month time from the date of commencement of the absence. Even going by such explanation, it is evident that no opportunity of hearing was given to the petitioner before taking the extreme measure of terminating his service. That apart, the first authority took into consideration. Now, my lord, here, my lord, I am inviting my lord, kindly see. That about the first authority took consideration previous instance of absence of the petitioner which had previously been accepted by the authority and as such could not be constituted as an indiscipline act for the purpose of adding the alleged offense of desertion, my lord. That about we find that at the inception of absence, the same was authorized, having been permitted by the authorities. The petitioner was also annexed the document. Thereafter, my lord, that upon as held by the Supreme Court as otherwise, permanent employee is guaranteed security of tenure, and in such cases, an opportunity of hearing has to be given before taking extreme measure of termination. In the present case, as such, clause 6.19 of the 1963 manual has to be read with, and in the light of Article 311 of the Constitution, which has not done by any of the authority below. That about the petitioner cannot be labeled with the stigma of having deserted in the true sense of terms, since he has all along been discharging his duties as a permanent employee and there has been no previous instance of misconduct to show that he was in indiscipline in the true sense of the term. The absence of the petitioner was merely a fallout of his continued physical infirmity, as such the punishment meted out was harsh and disproportionate to the offense of the said unauthorized absence. In such view of the matter, we are of the opinion that the respondent ought to have meted out lesser punishment. In that view of the matter, so and so allowed, and they said that, no, my lord, they challenged it before the Supreme Court, my lord. This order was carried.
You said that SLP is not admitted.
Not admitted. My lord, I appeared, my lord, and the honorable judges said that you will do whatever you like by going complete, by giving complete go by to Article 311. And therefore it was dismissed, my lord. Now I rendered, my lord, more than 20 odd years of service. What I am asking, my lord, without giving an opportunity, without conducting a disciplinary proceeding, whether I can be thrown out of service. Now, my lord, this was, I will just place those pages, my lord, that this was carried in an appeal before the statutory appellate authority. And the appellate authority, my lord, by the order dated 31st of July 2023, page 80, affirmed the order, my lord.
At page?
Page 80, my lord.
80.
80. Now, my lord, may kindly see the affirmation order.
31st July.
31st July. Now, my lord, may kindly see the order, my lord, one-page order. Total non-application of mine. Only factual aspect was stated. One page, all the facts, my lord, that this date, this date. This is total non-application of mine, my lord. Affirm the order. Now, my lord, may kindly see the order passed by the tribunal. It starts from page 137.
Yes.
My lord, this pages from 138 to 141 is the facts, my lord, what we have stated and what they have contended. And thereafter, page 142 is the rejoinder, wherein I have stated this, my lord, 6.19 cannot override Article 311 2B. Now, my lord, the court's reasoning is from page 143. The court says that admittedly, the applicant was unauthorized absent and absentee notice was issued. This again, my lord, the facts were reproduced, my lord, that these all facts. Thereafter, my lord, kindly come to page number 145, para 8. It says, however, from the perusal as well as the reply, it is noted that the applicant was a habitual absentee. My lord, this finding, I say, my lord, once it was regularized, thereafter this finding, because, my lord, I work and I have given the reason why I was absent, my lord, I had some issues, my lord. I was appointed in the year 2002, prior to 2017. At no point of time there was any unauthorized absent on my part, my lord. And once this was regularized by the authority, this cannot be taken as a ground to negate my claim. Now, my lord, thereafter the dates were reproduced, my lord, which was the second punishment. And thereafter, from the above, page 1.
Two earlier occasions, departmental proceeding was initiated.
Yes, was initiated.
In both the occasions.
Both the occasions. My lord, if my lord, please, I can place the memorandum of charge also in both the occasions.
No, it is recorded here.
Yes, it is there, my lord. It is there. I have enclosed also, my lord. Now, para 9, my lord. Yes. Para 9, my lord, 148. So these facts were recorded and here the court arrived to a finding. From the above, it is noted that he was served with memorandum of charge on 2018 and proper department proceeding was held and the respondent was regularized the service. Again, his unauthorized absence was treated as loss of pay, dated so and so, followed by another spell of unauthorized absence. However, his reinstatement in service so and so, wide order dated treating the period of unauthorized loss of pay, dated so and so by imposing a minor punishment, black mark against he declared desertion for 50 days. and 61 days thereafter, he cannot claim that there is a violation of principle. Even he was asked to appear before the authority for explanation. However, after the confirmation of the desertion as per the police manual, which is still in vogue, here, my lord, the court went wrong. I may submit this, my lord, because wait, he was only made an application on the ground that he's having some family problem. Therefore, he cannot join his duty without any detail of so and so. Whereas from the provision of the case of Ramu Sekar, it is noted in the aforesaid order. Observe, the petitioner cannot be labeled with. My lord, this only the portion, the earlier portion which I have read, that was not quoted, where the court said on earlier occasion also he was unauthorized absent, that was regularized. That judgment which I have relied, my lord. Only this portion the court has quoted, and therefore it is quite distinguishable from the above mentioned. On this score, my lord, this order was passed. So, my lord, my argument is, my lord, by invoking 6.19, they cannot override Article 311(2). And admittedly, they are aware of the fact that the procedure, even if you are invoking 6.19, you ought to initiate a disciplinary proceeding that they have done on earlier occasion. So this time they have went for a shortcut. And my lord, I respectfully submit, my lord, the order which I relied, my lord, this is aptly applicable in the instant case. Since, my lord, in that case also, my lord, earlier also he was unauthorized, the court has considered.
Sorry, your submission. Yes, Mr. Chakra.
My lord, firstly, my lord, the rule in question, my lord, has not been challenged. So, my lord, the rule, admittedly, even as per the petitioner, my lord, the procedure prescribed under the rule has been followed. But they have not challenged the rule. If they are saying that the rule is contrary to the Article 311 of the Constitution, then they had to challenge the rule, the constitutionality of the rule, my lord. That has not been challenged. Secondly, my lord, as has been recorded, my lord, by the Central Administrative Tribunal, if my lord sees paragraph 8, that, my lord, there is a whole chart which has been given, my lord, to show that how he has been a habitual absentee, and in fact departmental proceedings were conducted also on several on earlier occasions. So, my lord, this is a fit case where the exception to Article 311 can be attracted, because, my lord, it is pointless to have a further departmental proceeding when already twice in the past it has been done. And in the facts of the case, the police force being a disciplined force, my lord, it is expected that, my lord, that some degree of leeway has to be given, my lord, because if my lord sees the chart, my lord, there is right from 30th October 2016, my lord, right up to 21st March 2023, the person has been absent on different during long phases. So, my lord, and the decision in Ramu Shekhar has also, the CAT has taken pains to distinguish that by saying that in that case, from the facts, it was evident that the person was not a habitual absentee, unlike in the present case. So, my lord, my humble submission is, my lord, as long as the statutory rules have been followed, my lord. Now, if it is their contention that the rule has been followed, but still the rule is violative of the Constitution, my lord, then they have not challenged the violations of the rules. So, my lord, the CAT has applied its mind to the facts of the case, and, my lord, detailed judgment has been passed. And even assuming that 311 is applied, this is a fit case where an exception may be made to the rule, because having repeated departmental proceedings in respect of a habitually absentee employee, my lord, would not be would be a formality, my lord, because it would not really further the cause of justice. That is my submission, my lord.
That has to be explained. A clarification. So,
already taken in service for that.
Are we come to the The judgment and decree of the first appellate court has been set aside. It is held that the suit is filed within the statutory period of time and is not barred by limitation. The learned first appellate court is directed to deal with the appeal on merits and dispose of the same upon granting reasonable opportunity of hearing to the parties in accordance with law. It is made clear that this court has not gone into the merits of the case, and any observation made herein shall not be construed as an expression of opinion of this court on merits.
Yes. Obliged.
Item number 2, CRF 35/2025.
My lord, I am appearing for the petition, my lord. My lord, here the
Before
facts,
starting,
the facts
may I
is,
submit this. Seeing this case on earlier occasion, application was filed by the petitioner for quashing of the FIR at that relevant point of
Oh,
time.
now it is charge sheet. That is.
Not a charge sheet. The defect of complaint was given an opportunity by this court and he appointed a lawyer also.
my lord, that was at the stage of FIR. Now I am challenging the investigation conducted by the investigating state authorities.
What
No,
are the allegations?
My lord, kindly, I am just placing the fact, my lord.
420, 460, 471, so the defect, it should be 34, you've made 31.
420 and
First handle is wrong,
Well-
it's correction.
420 and 34, my lord.
34 has been recorded as 31.
Yes, my lord. Yes, my lord. My lord, the charge sheet was filed only under section 420 and 34. Next, that is impugned charge sheet. Now, my lord, the facts, my lord, can you hear the facts? That a paper publication was made, my lord.
If it takes time, I'm not.
No, my lord, it will not take
Yes.
time. My lord, it will not. No, it will. My lord, my lord, I will not argue for more than 10 minutes, my lord.
9 matters.
No, my lord, I am just placing. My learned friend knows that is nothing. What happened, my lord, can you hear? My lord, I am armed with 3 Supreme Court recent judgment of July. My lord, a paper publication was made through a broker saying that we intend to sell the land. We seen the said paper publication, we contacted the broker, and thereafter we intend to purchase the property after seeing the property. Thereafter, these petitioners were taken to the recorded tenant, and thereafter deal was finalized. The broker has taken the entire sale consideration amount, but the broker has paid certain amount to the de facto complaint, that is the owner, and rest amount he retained. That is the finding in the charge sheet also. Now, my lord, when he retains certain amount, the broker has, after a year, after the execution of the sale deed, mutation proceeding was initiated, mutation was culminated, and after a year, the de facto complainant filed a case making allegation against the broker that broker has received all the amount but not paid the amount to me, and we were also arraigned and accused in this said case. Now, my lord, the charge sheet was filed. The police clearly in the charge sheet says that the broker received the amount and he did not pay 62 lakhs to the de facto complainant. Now, this is the charge. Now, my lord, whether, because the allegation is pertaining to the broker, I am not on that. Whether this constitute a criminal offense or not, I am just placing the, my lord, I am just placing these 2-3 documents, my lord. I will not take much time. My lord, page 29 is the paper.
All these matters are pertaining to the same.
Same charge sheet. Same charge sheet.
Same charge sheet, same one.
They have purchased together.
Purchased together, my lord.
It is 200 square meter each. They are the.
My lord, plotting was done. They have purchased it, my lord, by paying the amount. Page 29 is the paper publication, my lord.
Yes.
at the right hand side from the bottom, plot for sale. From the bottom, my lord.
Yes.
There is the number of the broker, my lord. This. Now, my lord, on the basis of this, we agree to purchase and a sale deed was executed, my lord, on 16th of June 2022. The very next page is the sale deed, my lord, 30.
Yes.
My lord. Now, my lord, may kindly see page 34 of the sale deed. Our names are reflected, my lord. We are the purchasers, my lord. Now, my lord, may kindly come to page 38.
Yes.
38, my lord, it says, and whereas the vendor is being the absolute owner of the said property has agreed with the purchaser to sell the above said landed property for a sale consideration as the above land was already disposed of by the vendor to the purchaser in earlier as per the valuation of the above said land. My lord, thereafter these all documents were obtained, my lord. Here, my lord, we are governed by special law. We are not the owner. Therefore, we have to obtain all the documents from the government. These all documents were issued by the government on the basis of the application made by the broker. Now, my lord, may kindly come to page 40.
40.
40.
Yes.
It says, and whereas all the right, title, interest, property, claim and demand whatsoever of the vendor into or upon the said landed property hereby conveyed into the purchaser, their heir, executor, successor, administrator, assignee, absolutely and forever as ordinary pass on such sale, and that the vendor further transfer and convey all right of ways to the path so and so, easementary, everything. Next paragraph. Do hereby convey and declare that for herself and her heir executed representative and assign that she has perfect title of the so and so, so and so.
But these are not under challenge at all.
These are not under challenge. I say, my lord, after receiving the entire sale consideration amount, page 42. This is a document registered under the Registration Act, my lord. Page 42, she says, I have received the entire sale consideration amount. Now, my lord, after this, my lord, there is a process of mutation, my lord. My lord will get it at page 54. The land was subsequently mutated in my favor, in our favor. Page 54.
Yes.
Now, my lord, this mutation was recorded. My lord, this sale deed is of 16th of March 2022. My lord, may kindly have a note of it.
Yes, yes.
And record of right, my lord, this is the record of right where the name of all the incumbents are mentioned. And my lord will get at page 55. This mutation was effected on 30th of May at the bottom, 30th of May 2022. Second page, my lord. At the bottom, remarks. Remarks, my lord.
There is remarks.
At the bottom, my lord. After the names.
Remarks, yes.
Yes. Third line, my lord, is the date. RC case number and order passed on
13th November 2017.
No, my lord. 2022 is the mutation in our favor. I am sorry, my lord. 26 December 2022. Now, my lord, before this mutation was allowed, the complainant also surrendered her land, my lord, on 30th of May 2022. That is also recorded there. Now, my lord, so our right was accrued, sale deed was there, subsequent mutation is a proceeding under the special law governing the affair where all the parties are called, opportunity was given, thereafter only mutations are being effected, my lord. That is under the special law. Now, my lord, she made a complaint under section 156(3) before the authority, before the court at page 58, because she initiated a complaint, police did not initiate an FIR. She made a complaint. Now, my lord, kindly come to page 58, third paragraph.
Yes.
Having heard the learned advocate for the complainant who submit that the accused number 1 is the broker and the complainant decided to sell their land through the said broker who proposed the accused number 2 to 10 to purchase the said property from the complainant. The complainant number 1 is the recorded tenant of the land bearing survey number so and so, and all the formality of execution of the sale deed and its registration was done by the accused number 1. The further case of the complainant is that the complainant are less educated and studied in Hindi medium, having less knowledge about registration and taking advantage of the position, the accused.
Here the allegation against all the
No, but the allegation is only against the broker. If my lord sees, we were arrayed as an accused. My lord may kindly see at the top they are saying, having heard the learned complainant who submit that the accused number 1 is the broker. And thereafter all the accused names, and thereafter it says taking advantage of the position complainant, the accused caused the registration of the deed without handing over the entire consideration.
That is you.
No, that is the broker without handing. Acha, my lord, I will show the from further document. My lord will find further document. My lord may kindly come to. My lord may kindly come to page 61. My lord will have clarity, my lord, so far as this part is concerned.
Yes.
Last 2 line, my lord. This is a subsequent order of the magistrate on the basis of preliminary inquiry. It says all the formality of execution of the sale deed starting from preparation of sale deed and its registration was done by so and so. That is the broker, my lord, Mohammed Baksh. Anita, so and so, all names are there, my lord. Now, my lord may kindly see 9th line from the bottom.
Yes.
Although she has received rupees 32 lakh as he dealt with a broker to sell her land, he assured that soon after the registration, remaining amount would be transferred in her account. That is the broker, my lord. However, till date, she did not receive the remaining sale consideration. Now, my lord, on the basis of this, an FIR was initiated. Now, my lord may kindly come to the order of this court. When I have challenged it before this court, FIR was challenged, page 75. My lord may kindly come to page 76, paragraph number 4. Got it, man?
Yes.
It says from learned counsel has drawn the attention of this court to the following observation of the learned magistrate. From the inquiry conducted, statement of the complainant and witness, and from the document on record, it transpired that Anita Bahadur, Sheila Kumari, and Lalita Bai has approached a broker, namely Mohammed Baksh, who has got them into sale agreement with different people. However, through the entire deal, all the vendor seller obtained their token money from respective purchaser. How they did not receive the remaining sale consideration amount from the purchaser. When asked the purchaser, they said that they have given the remaining sale consideration amount money through various check and cash to Mohammed Baksh and Sehnaz. Sehnaz Begum was his wife, my lord. However, those monies were never given to the original seller by Mohammed Baksh. Further, the purchases were also never got introduced to so and so. Although alleged Mohammed Baksh claimed to have given the sale consideration money to the vendors, he does not have any supporting document. So, my lord, the party says that I have not received. Mohammed Baksh says I have paid it. Ascertain the same. The dispute land in the instant suit is situated at so and so. Having gone through the petition under section so and so, I find cognizable offence has been made out. So the prayer for the complaint to direct the SHO so and so allow. Now, my lord, para 5, my learned friend's submission, he says that it is well settled that FIR is not considered to be an encyclopedia of what it is mentioned therein, and the matter require further investigation. In fact, of the petitioner was granted anticipatory bail, and any apprehension that the petitioner may be named in the charge sheet is without any basis unless the investigation is completed. Now, my lord, para 8, the finding of the court. The FIR was never treated to be substantive piece of evidence and can be only used for corroboration as contradiction the informant evidence in that FIR. FIR is not an encyclopedia disclosing all facts so and so. The true test of a valid FIR is to ascertain whether the information furnished provide reason to suspect the commission of an offence to be investigated by a police officer under section so and so, so and so. Now, my lord, para 9, the court says, although it prima facie appear that the dispute are essentially between the owner of the properties and broker, as would appear from the observation made by the learned Chief Judicial Magistrate Port Blair while directing registration of FIR, it would be inadvisable at this stage to cause the FIR as the investigation has not yet been concluded and no charge sheet has been filed. It is equally possible that at the conclusion of investigation, the final report may not include the name of the petitioner. This order was passed. Now, my lord, the charge sheet was filed. FIR was initiated under section 420, 468, 471 and 34. Charge sheet was filed only under section 420 and 34. Now, my lord may kindly see, charge sheet starts from 81. My lord may kindly come to page 95 because up to that is the name of the accused persons.
Yes, 95.
95, relevant, my lord may kindly come to page 96. Last paragraph. This is the finding, my lord. Finding starts from subsequently on 2710. It last paragraph says the complainant Sri Anita Bahadur has appointed Lalita Bai as a power of attorney holder for the land bearing survey number so and so for the purpose of selling the said land. The general power of attorney was duly notarized on so and so between Anita Bahadur and Lalita Bai. Accordingly, Lalita Bai met Mohammad Baksh, a land broker from Garacharma, and they published an advertisement in the local newspaper for the sale of the said land. In response to the advertisement, several interested parties approached, who then acted as the mediator and so and so, so and so. Thereafter, Anita Bahadur and Mohammad Baksh enter into a sale agreement with so and so, so and so. Now, my lord, may kindly come to 98, my lord.
Yes.
During the course of the investigation, the bank transaction detail of vendor, purchaser, Mohammad Baksh and Srimati Sainaz Begum, wife of Mohammad, were obtained from the respective bank and scrutinized in relation to the sale deed and sale agreement. Upon scrutiny, the transaction that took between the concerned parties are tabular. Now, my lord, may kindly see the transaction. My lord, Mohammad Baksh and his wife, all together, they retain an amount of rupees 65 lakhs, 42 and 23. Now, my lord, next paragraph. That is next page, my lord, 99. It says, it reveals from the above that the vendor Anita Bahadur received 16 lakh, power of attorney holder received 13 lakh out of the sale consideration amount, that Mohammad Baksh received a sum of rupees 42 lakh from the purchaser, and Sainaz Begum, wife of, received a sum of rupees 23 lakh 20,000. Now, my lord, on the basis of this, now the finding is that we have paid 2 lakh or 3 lakh is balance. This is the finding. Now, my lord, thereafter, my lord, may kindly see the page 102A, my lord. Role of Mohammad Baksh. He was contacted by Lalita Bai to act as a mediator broker for the sale of the land bearing so and so. Along with Srimati Lalita Bai, he published an advertisement for the sale of plot in the local newspaper and subsequently entered into a sale agreement. He undertook, my lord, may kindly note this, he undertook all official correspondence with the office of the Deputy Commissioner and the office of the Tahsildar for obtaining sale permission, non-encumbrance, so and so, so and so. He collected a sum of rupees 42 lakh from the purchaser and convinced the vendor to sign the sale deed. Got it, my lord?
Yes.
Before the sub-registrar for the registration of land in favor of the concerned party. However, he failed to remit the amount to the vendor and the power of attorney holder, Srimati Lalita Bai. This is evidence that Mohammad Baksh has cheated the complainant, and accordingly an offence under so and so is made out against him. Now, my lord, thereafter, my lord, may kindly come to page 104.
Yes.
From the registered sale deed, sale agreement, bank transaction detail and recorded, it is evident that the land broker, Mohammad Baksh, in connivance with his wife, deliberately induced the 9 persons and collected a substantial amount from them without the knowledge of the vendor. Anita Bahadur and power of attorney thereby caused wrongful loss to the vendor. Additionally, the check number and proposed payment mentioned in the sale did not tally with the actual payment made to the vendor and the power of attorney holder. Furthermore, the purchaser also failed to pay the remaining amount of the sale consideration as mentioned in the sale deed to the vendor despite the registration of so and so, thereby constitute an act of willful cheating against the vendor. So, my lord, the allegation, pith and substance of the allegation against the vendors are, against the petitioners are that
Some amount is
due. Now, my lord, now, my lord, this is the allegation, my lord.
Is the amount still due?
No, they are saying that it is due. Now, my lord, they have filed a civil suit. The de facto complainant has filed a civil suit. My lord, may kindly
For
come
recovery.
for recovery. Page number 11. Page number 11. And I have got the plaint also in my hand. Page number 11 of my petition, paragraph number 30.
So 1 lakhs and odd is still due.
1 crore, and that is, they are saying that is not from us, my lord, because that gentleman has retained with him. Now, my lord, now the only question is, my lord, whether
Element of cheating.
Or is there or not. My lord, I will not make any submission on facts. I will rely 3 latest Supreme Court judgment on this because this is a civil remedy. no criminal offense is constituted, my lord, and the allegation at the cost of repetition, I am reading page 104. It says the purchaser failed to pay the remaining amount of sale consideration. This is the allegation against us. They have taken out a civil suit against all the, including the broker, in one civil suit. Now, my lord, I am relying 3 judgments, my lord. One after another I am giving, my lord. This is passed. This is passed on 14th July 2025. Now, may kindly come to paragraph number 7.
Yes.
The facts, my lord. 318 is the section for cheating, my lord. Now it is 318, my lord. We call upon the learned counsel appearing for the respondent to make us understood in what manner the FIR disclosed. My lord, here was a civil dispute, my lord. Disclosed commission of a cognizable offense.
You're in paragraph?
Para 7, my lord. Para 8, my lord. Para 8.
Yes.
We call upon the learned counsel appearing for them to make us understand in what manner the FIR disclosed commission of a cognizable offense. We also called upon the learned counsel appearing for the respondent to make us understand in what manner his client could be said to have been cheated as to constitute the offense of cheating. What we have been able to understand is that there is an oral agreement between the parties. The respondent number 4 might have parted with some money in accordance with the oral agreement, and it may be that the appellant herein owes a particular amount to be paid to the respondent number 4. However, the question is whether prima facie any offense of cheating could be said to have been committed by the appellant. How many times the high courts are to be reminded that to constitute an offense of cheating, there has to be something more than prima facie on record to indicate that the intention of the accused was to cheat the complainant right from the inception. The plain reading of the FIR does not disclose any element of criminality. The entire case is squarely covered by a recent pronunciation of this court in the case of so-and-so. In the said decision, the entire law as to what constitutes cheating and criminal breach of trust respectively has been exhaustively explained. It appears that this very decision was relied upon by the learned counsel appearing for the petitioner before the High Court. However, instead of looking into the matter on its own merit, the High Court thought fit to direct the petitioner to go for mediation, and that too by making payment of rupees so and so to fourth respondent as a condition precedent. We fail to understand why the High Court should undertake such exercise. The High Court may either allow the petition saying that no offense is disclosed, or may reject the petition saying that no case for causing is made out. Why should the High Court make an attempt to help the complainant to recover the amount due and payable to the accused? It is for the civil court or commercial court, as the case may be, to look into the suit that may be filed for recovery of money, or in any other proceeding, be it under the so and so. Why the High Court was not able to understand that the entire dispute between the parties is of a civil nature. We also inquired with the learned counsel appearing for the respondent number 4 whether his client has filed any civil suit or has initiated any other proceeding for recovery of money. It appears that no civil suit has been filed for recovery of money till this day. Money cannot be recovered, more particularly in a civil dispute between the parties, by filing a first information report and seeking the help of the police. This amount to abuse of process of law. We could have said many things, but we refrain from observing anything further. If the respondent number 4 has to recover particular amount, he may file a civil suit or seek any other appropriate remedy available to him in law. He cannot be permitted to take recourse of criminal proceeding. We are quite disturbed by the manner in which the High Court has passed the impugned order. The High Court first directed the appellant so and so. My lord, thereafter it was quashed. Now, my lord, this is of this month, my lord, July. I'm sorry, my lord, last month. My lord, thereafter this judgment, my lord, this is also a recent judgment of the Supreme Court, my lord. This is of July 18th, 2025. My lord, may kindly come to paragraph number 6.1. Appellant number 1 is a 70-year-old. Page number 3, my lord.
Yes.
Appellant number 1 is 70-year-old wife of late army personnel so and so, and appellant number 2 is her daughter aged about 50 years, a resident of New Delhi. Appellant number 1 owns a piece of land measuring such and such at Telangana. The said land was gifted to so and so. Around the year 2020, the respondent number 2 approached the husband of the appellant, Major so and so, showing an interest in purchasing the said plot. At that time, the value of the plot was assessed at 7 crore. Unfortunately, so and so passes away before the agreement, whether written or oral, could be executed between the parties. In this case, the appellant that they found the management of so-and-so, they orally agreed to sell the so-and-so. The total sale consideration amount was settled at 5 crore 75 lakh. Para 6.4, my lord, they have paid 4.05 crore, my lord. Para 6.4. The dispute is at para 6.5. 6.5, they say, is that no further amount was paid to them in terms of oral agreement, whereas the complainant claimed to have paid a sum of rupees 75 lakh in cash to the appellant at the time of execution of the said deed. Now, my lord, may kindly come to clause 6.8. It was inter alia alleged in the FIR that so-and-so and her daughter induced the complainant, believing that they will sell the property so-and-so to the complainant for a total consideration of rupees 5 crore. The complainant has assured by the accused appellant that they have good relation with the neighbor plot so-and-so and they would ensure that he would sell this at so-and-so. Believing the word of the appellant, the complainant agreed and entered into an oral agreement to sell by paying rupees 75 lakh. Now, my lord, may kindly see, this is the, now, my lord, may kindly come to 6.13, my lord. In this case, my lord, 6.12, my lord, will find after the inception of the FIR, this lady was even arrested by the Telangana police. Now, 6.13 says, appellant number 1 was granted regular bail by the competent authority, but she actually came to release from prison on so-and-so, the Telangana police along with the police officer so-and-so. Being 6.14 says, being agreed, they have filed a quashing application. Now, my lord, may kindly come to para 7, my lord. Page number 11.
Let us go to the findings.
Findings, my lord. No, my lord, I just appraise the fact, my lord, this is with regard to non-making of payment. They said they have paid. Now, my lord, may kindly come to para 9. Having given our thoughtful consideration to the submission advanced at bar and after going through the impugned FIR and the pleading of the suit for specific performance filed by the complainant, we are convinced that this is a classic case of the complainant who seems to be wielded some clout in the state of Telangana, misuse the process of police investigation so as to entangle the accused appellant who are resident of so-and-so in a totally false and frivolous prosecution for the offence under section so-and-so, so-and-so. Thereafter, if my lord come to para 12, my lord. Thus, clearly the complainant has manipulated and distorted the facts and has used its influence for getting the FIR registered against the appellant. On a bare reading of the FIR, it is clear that a plain and simple dispute involving non-execution of a registered sale deed in terms of the so-called oral agreement to sell has been given the clock of a criminal case by misusing the criminal machineries. Not only that, this appellant being a 70 years so-and-so has been arrested. We are of the firm view, para 13, opinion that even after from the admitted allegation set out in the complaint, there was no justification for registration of the FIR and rather the complainant should have been instructed to avail the appropriate remedy by approaching the civil court. In gross disregard to all tenets of law, the impugned FIR came to be registered for allegation which has no element of any offence whatsoever, what to talk of a cognizable offence. The fact that appellant number 1 was arrested in a previous affair showed the clout of the company to which, my lord, thereafter, my lord, these are facts, thereafter, para 15, we feel that rather than awarding interest, it is fit case. My lord, thereafter, my lord, the court has caused it and imposed cost upon them, my lord, for misusing the government machinery. My lord, this is the latest judgment passed on 31st of July, my lord. My lord, my lord, here 2.1, if my lord sees second page, there was also an offence for 420, my lord. Now, my lord, this is with, my lord, the allegation is that there was an unregistered will. They say that it was on the basis of some forgery it was done. Now, my lord, on the basis of this, there were civil dispute also. After 60, para 3.11, my lord, an application for quashing was filed, my lord. Thereafter, my lord, at para 6, the submissions of the parties were recorded, my lord, of the, my lord, para 6 and 7, I will read, my lord, because it says during the course of submission, so and so, This is not a case where any allegation under so and so and prima facie, it was under circumstance make it apparent that the criminal proceeding were initiated only to abuse the process of law with the obliged aim for settling the civil dispute between the parties. Furthermore, it was contended that the High Court failed to appreciate that the mutation order in favor of the appellant was passed after granting full opportunity to the complainant respondent number 1, and that once the object filed by the complainant respondent number 1 were dismissed. Now, my lord, here also mutation was allowed, my lord, in terms of the special law governing the affair after the registration of the sale deed. Now, my lord, submissions were recorded, and thereafter, my lord, Bhajan Lal, even in my petition also, I have
I was
quoted.
actually looking for Bhajan Lal.
Bhajan Lal, I have quoted, my lord. I have quoted in my application itself.
Here also.
Yes, my lord. Para 40, I have quoted the relevant provision of relevant paragraphs of Bhajan Lal, my lord. And in paragraph 108, thereafter subclause, I have quoted, my lord. Now, my lord, here also it has been quoted, my lord. After this, my lord may kindly come to para 8.3 is the finding of the court. Upon giving our thorough consideration to the argument advanced at bar, we fail to understand as to how the allegation against the appellant herein, who are only legatees under the will in question, could be sustained in light of material on record. The allegation against the accused appellant in sum and substance are that they enter into a conspiracy.
The facts are different in this case.
No, I am not on fact. I say, my lord, what I am on, my lord, this was absolutely a civil remedy, my lord, available to them, and they have rightly filed a civil suit for recovery of the amount. There is no criminal. Now, my lord, the court has said how these criminal machineries were invoked in para 8.6, my lord.
Yes.
And thereafter, my lord, several latest judgment of the Supreme Court were also considered. And para 9, my lord, page number 15, the court has said on careful consideration of the aforesaid judicial, we find that none of the offence alleged against the accused in the instant case is just another one in a string of cases filed in recent years that seeks to distinguish a civil dispute as criminal. So, my lord, my paramount argument, my lord, first judgment and second judgment is very apt, my lord. In this judgment also, my lord, they challenge they say that will has been fabricated. The court said if there is a civil dispute, you go and agitate the issue there. So, my lord, here, my lord, page 104, my lord may kindly have a note of it. 104, they say that we have to pay some remaining amount. Though in our petition, we have categorically said we have paid the entire amount. Assuming for argument's sake, if anything is left, that is a civil consequences, my lord, and already they have invoked the civil jurisdiction.
That's all. Yes, for the state.
Your Lordship, 1 minute, Your Lordship. Here, Your Lordship, they have challenged the FIR initially before this honorable court. At that time, they have made us as a party.
Yes, that time.
So we are the de facto complainant. So I am praying, Your Lordship, I may also be heard, Your Lordship. Because
My lord, at that time, they were a relevant party.
there are so many decisions.
That defendant wants to be heard, she has to be given an opportunity.
Your Lordship, law is settled now, Your Lordship.
Yeah, law is settled.
Yes.
So you need to serve.
I will serve her during the course of the day. Let the matter appear to. Let my learned friend argue today because my allegation is against them.
Are you ready for the hearing today?
Today it is not possible, Your Lordship, because today only I came to know that.
No, my learned friend appeared.
I appeared.
Earlier.
I have to go through the papers. You
No, I am saying that the public prosecutor may argue today.
Give a copy. I will come back day after tomorrow.
No, let it be tomorrow.
Sir, no, I will not
I'll
adjourn.
come
this.
day after.
I will. There's no further time to adjourn.
We also have made as a party, Your Lordship, when he has made it
My lord.
not required. You have taken a chance.
She has to be given a right of audience. De facto complainant has to be given a right of audience if she wants
My
to.
lord, I have argued. My learned friend can argue.
No, I cannot reserve this. Not possible. Your 10 minutes has taken us to 35 minutes.
My lord, I am seeking for an interim order. Further proceeding ought to be stayed. My lord, I have argued my part. My lord, no harm will be caused to any party.
Yes,
My
you are
lord.
on bail.
Huh?
You are on bail.
Bail.
And
Further proceeding.
it has been submitted.
Yes.
The arrested anticipatory bail was allowed, Lordship. Next proceeding for appearance of the accused. Next stage is for.
My lord, I am saying, my lord, that
Lordship, charge has been framed. If cost
End
by
of
this
this
court.
month, the next circuit starts. I don't think you'll need a. That's why I was asking. I mean, we've just spent so much.
no, my
time
lord,
for
why
it.
I am seeking for an interim order. No harm will be caused, my lord, on 25th. If my lord is satisfied, I am not saying that my lord pass a blanket order. If my lord is satisfied from my argument, let it be stayed for a specific period.
I'll give.
Other side has taken a
When is
chance.
the
Your
next date
Lordship.
for the trial?
Next date, I. That too.
When is the next date? Please tell me.
This month, my lord, date I don't know.
When is the?
Not available. Next date, LCR.
No, my lord, I will inform.
See, even a charge matter will be proceeded further, Lordship. If
My learned friend can say anything, everything.
There
If
is
it's a civil consequence.
Fit case for quashing the charge sheet.
If a prima facie case has been made out there, it's a good.
Your lordship,
ground
in
for-
any case, your lordship, what materials have been placed before your lordship and what materials I would be placing before your lordship, it is at.
I have placed the charge sheet. I have not placed any doubt. 29th of August.
Your lordship, but one thing,
Stays
My lord,
not
I am-
required, next circuit is for 25th.
let him place it before,
That's why I was asking for the next.
let him serve me a copy by that time.
Kindly, my lord, stay. My lord is convinced, my lord may stay, my lord, for a specific period.
Learned
Copy will be
counsel
given to
the
me.
de facto complainant appears in this matter and seeks a right of audience. Paragraph, the petitioner is rather bad luck. I wanted to dispose it off, but then do not be
My lord, may kindly stay, my lord. If my lord is convinced with my argument on the.
25th, the next circuit.
No, my lord, there is a difficulty, my lord. Why should I appear before the trial court any further when I have not come?
That
Why I have to appear, my lord.
the date is you said 28th.
29th, my lord.
Yes, the circuit start. That's why I asked for the date.
No, but if my lord is convinced, my lord.
29th.
But
So
if
you
my lord
can
is
just say
convinced,
now.
my lord, I am not on that. If
If
my lord
there's
is
a
convinced.
date prior to 25th, I would have definitely considered. There is no date prior to it.
My learned friend is
you-
present, my lord. He can argue with regard to interim prayer.
Not necessary, sir. When the date is not there, in the meantime, why do you require an interim prayer or interim stay?
They will come and seek for an adjournment on the.
Why would we do
The
that? That's
circuit
why
will be there to help
you have
out.
taken a charge by not serving
It's
me.
circuit from 26th August. That's why I'm not passing a stay order, not for any other reason. The petitioner is directed to serve copy of the application along with annexure thereto upon the de facto complainant and file affidavit of service on the adjourned date.
No, my lord, my learned friend is there. I am serving. She has appeared.
I will receive your lordship because I have appeared in this
In
case.
course of this day,
My lord, by tomorrow, my lord.
learned, directed to serve copy of the application along with annexure thereto upon learned counsel appearing for the de facto complainant by tomorrow. Paragraph, the matter be placed before the next available.
My lord, I will add the.
I was really interested in disposing of this matter. Anyway,
My lord, I will add the de facto complainant as a party. Leave may be granted, no?
before that, the de facto complainant be added as an added opposite party in the present matter.
Your lordship, one more small
Or
thing. your
title
lordship.
of the application be amended accordingly.
I am going to receive it, no doubt about it, but at least one notice be sent.
No, no, no. Otherwise, my learned friend did not have a right of audience
I'm
today.
representing.
My learned friend is having right of audience today then.
Since you are already representing, no
Because
further
your lordship,
notices.
earlier round of
No, no.
litigation, your lordship, they made the de facto
Maybe,
complainant
but
the
today
party.
you are representing
Yes.
your own, so you don't need a notice.
Yes.
This is still 9,
My lord, I will take back the judgments, my lord.
please.
9.
Yes, next.
Item number 10, WP 339 of 2025.
Yes, anyone appearing?
My lord, I am appearing, my lord. My lord, here, my lord.
In this case, respondent number 2 is the essential concern of the police department. Sorry, Lord. One is the essential concern, police department. I used to appear, but I did not, whether sir, sir.
Yes, yes.
Have you served?
Yes, my lord. Served on 22nd of July.
Where is your affidavit of
My lord, I
service?
have not filed, my lord, since my learned friend. This is my lord service by hand on 22nd of July. My lord, repeated orders were passed by the trial court upon the SHO so that the order which interim order was passed should be enforced. But my lord,
That is
the
not being done.
SHO, no, my lord, the SHO is, if my lord, I will show one after another order, my
And
lord.
there are private respondents.
Private
also.
restaurants are also there, my lord. They are the
Where
plenty.
is the, you are for the tehsil. Where is the service? Private respondents,
My lord, we will just,
track report.
just not today, my lord. My lord, allegation is against the respondent number 1 only, my lord.
But since you have
Since,
imputed them.
yes, my lord, since they were plaintiff as such, I have, because my lord, despite of an interim order passed by the court, the plaintiffs are merrily carrying construction. The court has passed on 2 occasions, 151 application, court passed an order. Thereafter, once again, I filed an application, court passed an order. And even directed Tahsildar to assist if they require the assistance of the Tahsildar, they can take. Despite of that, my lord, the SHO is not making any attempt to enforce the order of the court.
Come back tomorrow?
No,
Can you come back with the service tomorrow?
my lord, because
Is it served?
it definitely it might have been served, my lord, because it was sent on
22nd of July. My lord.
I'll adjourn it for a day.
My lord.
On prayer of the matter is adjourned for the day. Please come back with the affidavit of service so that I can deal with the matter.
What's my appearance for the response?
Yes, please give your name.
Yes. One.
Next.
Number 11.
And for the response.
Whether the private responses has been served or not.
Where is the service? Private respondent, please show me the service. File, please.
The decree, decree was passed, on the basis of the decree, won't be submitted.
There is no private respondent.
Passed over for a.
Very good. Pass it.
On the basis of yesterday, it's not by my hands. On the basis of the decree, the Tehsildar was asked to subdivide the plan, the demarcate that.
Oh, it is that matter.
Yes, sir. So on the basis of until and unless the.
Let it be passed over. Let us see.
Item number 12. W3 of 2025.
I'm the respondent.
Yes, what is the prayer?
Prayer is to hold demarcation in the subject line of the writ petition. Very unfortunate situation, my lord. This writ petitioner is running from pillar to post. His circular is purchased land, my lord. On the 10th of May, registered sale deed. His name got mutated in the location registered paying land and cancel authorities. But still.
Have you filed a representation before the authorities?
Yes, my lord.
Where is that?
Yes.
Page 47.
43 is my online application. So nowadays they are not accepting offline application. We have to approach through online. I approached through online.
You opposed. Why did you oppose?
I approached in online.
Approached.
We have not. And this is my application.
My page 47.
Yes, yes.
About the area of demarcation. The surveyor's report.
There is a reason for not carrying it out.
Yes,
Why?
Is the private respondent also?
Neither they want to utilize my land, nor they want to conduct demarcation. One or the other way, they want to stall the demarcation. What is that happened, my lord? May I place the case, sir?
Yes, please place your case.
Yes.
What
What is?
private respondent? She's not paid as a private respondent, but
This is not required. Already they settled in order from this court. Division bench while sitting over in a matter of Shaktivel, same matter, again Shaktivel has been,
my lord is possible.
Tahsildar has been directed to
Division
edit the writ petitioner from hearing from the land of 34
Yes.
oblique 1 oblique 14.
Yes.
What I am praying, my lord, I am also a recorded tenant. I am purchased based on a registered sale deed. I am paying land revenue. What harm will cause to the private person? I fail to understand, my lord. Let my land be demarcated. My area has been sold so that I can shift, my lord.
What
There
is
is-
the difficulty in
Yes,
demarcating
Oh,
ma'am.
his area?
It was already demarcated much
No,
earlier.
this was not demarcated. The whole.
His only prayer is for
Yes.
demarcating the
Yes.
subject land,
Yes, ma'am.
which you are occupying already.
Yes, madam. No,
They
that's
are
it.
not in occupation.
You are not in
Somebody else
occupation.
is in occupation.
We are saying, my lord, that to clarify this all things, my land has to be demarcated.
How do you say that it is your land?
Kindly
Where
see
are the
my record of
documents?
it. Yes, I have purchased, my lord.
There is, there is a
Yes,
sale
ma'am.
deed?
Yes, ma'am. Kindly see sale deed. Yes. My lord, kindly see page 2, my lord. This is the registered sale deed through which I purchased the subject land. Ma'am. The subsequently mutation was done, my lord. This is the sale deed, my lord, and page 28 is a record of rent. My name has been appearing, my lord. The sole recorded tenant.
Yes, that is recorded in page 47 also.
Yes, my lord.
What is should happen, my lord, this private respondent, who is adjacent plot order
This
34.
or this on page 47.
Yes, my lord.
It says that you preferred an appeal against the order passed by the honorable
Yes,
single
that's
bench. What
already
appeal is
been
this?
decided, my lord, by my lords only. It's a altogether different issue, my lord. What I'm praying, my lord, this subject, this proceeding was held up for 34/1/14. This pertains to 34/1/15.
Do you have the order of this appeal?
My lord, recent bench already decided. I can place, my lord. This
Please show me the order because I am not, I cannot recollect.
recent bench matter, my lord, wherein Tahsildar has been directed to evict me from the suit within 3 months. So where we I go, my lord, because I also.
Suit land is a different land. They are in unauthorized occupation of a particular land, right?
They are in occupation of 34/1/14.
Here, alleging.
Oh,
They
this
are
is-
not in occupation of 34/1/15.
My lord,
Somebody else is in occupation.
34/1/15.
This land, my lord. If my lord.
34/1/15 is demarcated already.
Yes.
my lord,
The
I am-
petition,
my lord,
because.
kindly see, my lord, surveyor present.
Investigations thereafter appeal,
My lord.
it was dismissed again.
No, he is claiming on 15, right?
Yes, my lord. My lord.
And the sale deed, what kind of
It's
sale
not
deed have you
15.
given? Have you seen?
My lord.
Please come to page 19.
Writing is part of
It's blank.
It's an old one, 2015 used to place in the paper.
An area of 0.0200
Yes, ma'am.
hectares.
This is my recorded area, my lord. I'm harping on this particular area only, my lord. My lord.
So why don't you demarcate this,
Yes, my
this
lord.
area?
My lord, may kindly come to page 46.
Yes.
The letter was given by the council of the opposite party.
The whole thing, my lord, may I please just for a minute, my lord. Why this?
Give me a minute, please. Will be demarcated. So where is the demarcation?
Will it be demarcated thereafter? Since the matter is sub judice before the Honorable High Court, this was.
So now the matter is no longer sub
No longer
judice.
sub
So why don't
That
you
was
demarcate?
dismissed.
Yes.
Why don't you demarcate?
Still they are telling, my
Right?
lord, the private respondent is time and again making a representation to desist from carrying out demarcation.
No,
We
let it
already
be
examined-
demarcated in presence of the petitioner
Yes.
and all others concerned. The innocuous prayer of the petitioner is for demarcation of the land in question purchased by him by virtue of a registered deed. Comprising the schedule, comprising 0.0200 hectares in survey number 34/1/15. Learned counsel paragraph. Learned counsel for the petitioner submits that the petitioner purchased the said land
Page 12.
on
18th day of-
by virtue of a registered deed on 18th May 2015. You are not able to occupy this land, right?
No. I'm not able. Since there is a report being called for, it shows that I've been allegedly been possessed.
Motherland.
And now they don't want to me to demarcate my land to so my boat to occupy the same. My lord, what harm I fail to understand, my lord. If they will demarcate and show my pillar, my lord, I will.
In the earlier writ application, we have annexed all those documents, my lord. If my lord, it started tomorrow. my
This
lord, I can
part you have
produce-
demarcated.
Yes.
Oh, my
Yes,
lord, why they
my lord, take my
kindly
leave.
see the
This
report
matter
of the
tomorrow,
surveyor,
I
my
will
lord.
Come back tomorrow, let me find out.
Only one submission.
Of
Kindly
this
see
survey
the report
numbers.
of the surveyor, my lord. They issued demarcation notice. Then demarcation would have complete, they would have
Yes,
not
yes,
issued
appeal
any
was
demarcation notice. Kindly see demarcation notice, my lord.
Demarcation notice was
Yes.
issued on 1st July
My
2025.
lord, kindly see page 44, my lord. With reference to the application dated 5/5/2025, land bearing survey number 34/1/15 measuring 0.02 hectares belonging to Shaktivel, son of Subbiya, shall be demarcated on 9/7/2025 at 9:30 AM. This was
So where
issued
is
by
that
care office.
demarcation report? 9/7/2025.
they not conducted the demarcation, my lord, citing that this matter is
Due to this,
47.
page 46.
The appeal is with regard to 14, not 15.
Fine.
So why, what is the difficulty in demarcating 15? So that's what I'll give a direction for demarcating 15.
Done it, and we have already informed the, this petitioner that somebody else, it's not, Mr. Arun Prasant's client. That's
So
the name.
here this all process, my lord, we are applied for this demarcation to get my land demarcated, my lord, so that I can shift from the.
Since prima facie it appears that he is the owner,
But Sarla back here. Actually, he has encroached upon, he has taken the illegal occupation of Sarla Vaidya's
that
land.
is 14, that is not the subject
That's
matter of
14.
this
This case,
writ
this is
petition,
not the
right?
subject matter, but.
So
somebody
here
else
his
has
prayer is
or-
demarcation of his part,
Fine.
owned by him. Demarcate that part.
That has already. been
Because
demarcated
practically
and-
speaking, if he's evicted from 14 and his 15 is not demarcated, where does he go? This is apparently,
This reference can be given, the notice,
yes, yes.
the notice of demarcation.
What did I say?
The notice wide RC number we mentioned,
It's at page
the top,
40.
44, the RC number is there.
Yes, paragraph learned counsels for the parties referred to a notice issued by the revenue inspector on 21st June 2025, V-Day RC number TPB/2025/821, wherein it is stated that the land in question belonging to the petitioner would be demarcated on 9th July 2025. So the petitioner submits that such demarcation has not been held till date. Paragraph, in view of the above, comma, this court directs the respondent number, directs the second respondent to demarcate the portion of the property, demarcate the plot of land referred to in the notice dated 21st June 2025 within 1 month.
May I say this, already my lord, a time has been stipulated, eviction order, and division bench is also upon the findings of single court. Already time has been stipulated for eviction. Let this speedy demarcation so that.
Cannot be done tomorrow, right?
I am so sorry.
A month has to be
I'm so
given.
sorry.
It's the authority who has to do it. They have several other duties to perform. Within 30 days from the date of communication of this order, upon service of notice to all concerned, including the petitioner.
Including petitioner or adjacent lot holders.
I've stated all concerned.
May I say this one? Till such time, no coercive steps against this. I think for one of 15, like 15. So for 15.
What coercive steps are you expecting in 15?
After demarcation.
Are you expecting any coercive steps in 15? No, you are expecting in 14. That's not the subject matter.
That's why.
The writ petition is accordingly disposed of. Since no affidavit has been invited, include that adjacent facts. Next.
Item number 30, WPA 354 of 2025.
In this matter, can also be disposed of. Law point has been involved. What is happened? We sent the notice to respond number 2 is not by middle and the month. Service is not yet available. Let it come tomorrow. This gets only taken.
The one representation is pending. Page
It is not about representation. This is a serious concern of this island, which has been carried out in this writ petition. Let they serve because track report shows it's under transit. Unless and until they will serve with the notice to come with a plea that they was not heard before passing.
Whom you are representing one administration. You want to serve two.
Yes, my registrar is the
Registrar.
answering respondent so far this writ is concerned.
You want it tomorrow? You can
Yes,
serve by tomorrow.
Yes, ma'am.
On prayer of the petitioner, the matter is adjourned for the day. Next.
Item 14, WPA 364 of 2025.
Not affected. Since
Day after tomorrow, we'll file a.
day after tomorrow, not possible. Since service upon the respondents is not complete, comma, the matter be placed before the next available circuit. Next.
Item number 15, WPA 370 of 2025.
Item number 15 to 19, those are that similar matters, Your Worship, related to the tax election.
Relating to
Tax matter election. That argument was advanced, Your Worship, on Saturday. This is the order which has been passed by Your Worship. So I would be seeking the same order, same date of the order. All the cases, Your Worship, the date of the order is also the same.
My lord, our appearance may be recorded, my lord, with Mr. Rakesh Kumar and myself.
Shall I pass?
15 to
the same?
19.
My lord, so if it is the same matter, my lord.
Same.
Yes,
Same issue,
Same
Your Worship.
question, yes. The same order be passed.
my lord had observed that my lord has not gone into the merits at this stage. My lord.
The order, it has been observed.
Settled there? Yes.
My lord, my lord.
15 to 19.
15 to 19, Your Worship. Oblige, Your Worship.
15 to
My
19.
Item number
Intelligence, my lord, item number 12, my lord had just disposed of, and that also, my lord, with the line recorded that my lord has not entered into merit as a.
There is no question of merits in that matter. He has
Yes,
asked for
since he
demarcation, I have granted that.
Since they sent some courses, checks and all,
No, that is not with regard to some other property. I have not entertained that at all. I mean, there is no question of merits in that matter. It's only demarcation. That's the only prayer.
Item number
Yes.
20, WPA 357 of 2025.
My lord, I am appearing for the petitioner, my lord.
seeking time to filing my opposition, this.
I am
Oh,
for an interim order.
Fine.
I have not received the instruction.
Let it be not today, my lord, since because I am seeking for an interim order.
Let me go to the file.
Yes. This is the second round, my lord. First round, this court set aside the order passed by them and arrived to a prima facie finding that I have placed all the document before them. Despite of that, once again, the order which has been set aside by this court, that has been affirmed.
Where are the orders? Please show me.
My lord. My lord, may kindly come to,
8118.
no, I am just placing first the, my lord, first order is at page 77.
No, since learned counsel is asking for a stay, I would like to see the merits prima facie. Once.
If my learned friend is saying without instruction, let her come tomorrow because I want to argue the matter, my lord.
She'll come back with she wants to file an affidavit in opposition.
No, she said she has no instruction today. That's why.
She also does.
She has made both the submissions. So if there's.
I don't want tomorrow they say that we were not ready and.
Second round application. So we are filing my opposition.
But I am seeking an interim order because.
That's what I
Yes.
see. Why are you seeking an
My
interim
lord,
order?
page 77, my lord.
77.
My lord.
Yes.
My lord, I am a contractor. Civil construction is carried by me at Car Nicobar, and I am also having shipping business. I have my own ships and all. So, my lord, for carrying the construction work in Car Nicobar, I have to procure the stone aggregates and river sand from abroad and from different part of the country. So, my lord, in the said process, I procure river sand from Malaysia and I procure stone aggregates from a district of Tamil Nadu, my lord. That vouchers are there. Now, my lord, after purchase of the same, the ship is boarded at Port Blair. From here, we get custom clearance and all. Thereafter, the ship is the materials are transit to Car Nicobar. In Car Nicobar, also Port Management Board inspected, and thereafter only we were allowed to shift the materials. We shifted the materials all along. This business is carrying from last several years. Now, my lord, the new deputy commissioner who came, he, my lord, for whatever reason, I don't want to. So he, my lord, invoked a proceeding under the Land Revenue and Land Reform Regulation, which is not applicable. There it is applicable only where the mines and minerals are being extracted from this island. Now, my lord, on the basis of the said proceeding, without giving an opportunity of hearing, my lord, this order was passed on 25th of March 2025, my lord, page 77. Now, my lord will find whereas a revenue case was filed as per the proceeding in the where given ample opportunity and all this was written, my lord.
Alleging illegal transportation and dumping.
Yes, whereas we have documents and my lord, and they say that this is violation to the provisions of Land Revenue Land Reform Regulation, more particularly Regulation 201, which has got no manner of application so far as the stone aggregates and river sand which were purchased from other part of the country.
Yeah, this is minerals extracted or removed.
Removed. That is from this island.
Yes,
it
yes.
was never removed. Now, my lord, this was challenged by me before this honorable court, and this honorable court, my lord, passed an order on
91.
my lord 91. Now, my lord will find that this court has passed an order in page 96. The court arrived to a definite finding. My lord, may kindly see.
Yes.
The court says, on careful consideration of the entire material as placed before this court, and after hearing the learned advocates for the contending parties, it appears to this court that, and while imposing the penalty to the tune the respondent has resorted to the provision of so and so, at this junction, if I look the provision of the said, it appears to this court that the authority under the said subsection was empowered to impose in the event it find that any person has extracted or removed any material from any mines or quarry without the lawful authority. Now, my lord, this court has meticulously perused the order dated so and so is under challenge before in such order finds no whisper with regard to the finding of the respondent number 1 that any material have been placed before him to substantiate that the writ petitioner has extracted or removed minerals from any mines or quarry without any lawful authority. Such being the position, this court considered that the imposition of so and so under cover so and so is absolutely unreasonable and arbitrary in nature, and the same is thus set aside. Thereafter, the court say, my lord, before parting with this, on court think it pertinent to mention that since sufficient material have been placed before this court to substantiate at least prima facie that the writ petitioners possess sufficient document to establish valid transshipment of minor mineral from various part of the country and outside the country to Port Blair, and thereafter again to Car Nicobar Island, this court, while allowing the instant writ petition and while set asiding as passed by the direct the writ petition to appear. Thereafter, the court, my lord, set aside it, and court said you appear before the subdivisional officer. Now, my lord, may kindly see the order, my lord. My lord, immediately after the order of the court, we immediately, before they further issued notice, we submitted all the document once again, so that we don't want to take any chance, my lord. Now, my lord, kindly see the order once again. Page 118.
Yes.
This order, my lord, narrated the facts and says,
Page 119.
119 says,
Violation.
after thorough examination of submission and office record, violation of Andaman Nicobar mine mineral rules. The petitioner failed to submit mandatory form 3 and so which mandate declaration of landing of importing minor. My lord, this is not applicable. We have submitted all the documents, even those were part of the earlier writ petition, my lord. Now, my lord, the sale of stone aggregate to local resident, this was not the subject matter of the said proceeding. Everything is there, my lord, part of the writ petition also. Now, my lord, what I am on for the purpose of interim order, if my lord sees the page 120, based on the detailed submission, the petitioner has conducted unauthorized transaction in so and so, the petitioner acted in contravention of so and so. The seized and administrative action initiated by the deputy commissioner under order dated so and so is found to be legally valid, justified, and in accordance with law.
This
Accordingly,
administrative action was challenged earlier.
challenge set aside by the court.
Yes.
Accordingly, the order passed by the deputy commissioner stand affirm. The petitioner are directed to refrain from any unauthorized. Now, my lord, under the dint of that said order, the deputy commissioner directed us to pay 3 crore and odd. If my lord sees that order, operative portion, page 78, this amount we have to pay. ₹3.86
I'll direct you to, I'll grant you liberty to come back with affidavit in opposition. I'll stay this order for the time. It's palpably illegal. The, I heard learned counsels for the parties. The petitioner.
Contradictory है ये finding का कोर्ट का नहीं और वो ना कॉन्ट्राडिक्टरी है इसका कॉन्ट्राडिक्टरी ये पेज नंबर 96 का कॉन्ट्राडिक्टरी
Petitioners have been carrying on business and have been importing silica sand from Malaysia and purchasing stone aggregates from Chennai and other parts of the country. An order was passed by the Deputy Commissioner, Nicobar District on 25th March 2025. Directing the petitioners to strike it up, imposing penalty upon the petitioners to the tune of rupees 3,86,43,200 for illegal transportation and dumping of stone aggregates and sand. Provision under section 201 within bracket 6 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation, 1966, as well as section 34 of the Andaman and Nicobar Islands Minor Minerals Rules, 2012, were invoked in imposing such penalty. The petitioners were not granted an opportunity of hearing prior to imposing such penalty. The order was assailed by the petitioners before this court, and by an order passed on 16th May 2025, this court set aside the order passed by the Deputy Commissioner and directed the authority to revisit the issue in the light of the observation made in the said order. Despite such direction, the authority took up the matter for reconsideration and by the order impugned dated 18th June 2025, affirmed the order passed by the Deputy Commissioner, which was earlier set aside by this court. Paragraph: upon consideration of the material on record, this court is of the view that the matter needs to be heard on merits. Paragraph: learned counsel for the respondents seeks to use an affidavit in opposition in this matter. Paragraph: affidavit in opposition be filed within 2 weeks from date. Affidavit in reply, if any, be filed within a week thereafter. Paragraph: the matter be placed before the next available circuit bench. Paragraph: the order impugned dated 18th June 2025, passed by the subdivisional magistrate, Nicobar district. There should be a number
My lord,
in RC number. This is the number, right?
my lord, RC number.
RC number ACN/01/2025 be stayed till 31st August 2025 or until further orders, whichever is done. Next.
My lord, in this matter, my lord, may I pray for, may I come at 2 p.m., my lord? If your lordship so desire, kindly short password.
2 p.m. will not be possible, sir. I may finish the matters by then. Please come little earlier. Come at 1:30, please.
1:30, my lord, I am coming at 1. Grateful, man, grateful.
I'll further respond.
1:30. Next.
Item number 22, WPA 3.
Yes, anyone appearing?
Item number 22.
22.
This matter pertains to a senior advocate of this bar, my lord, who was known for some time. This
Trustee, that matter report already within the record regarding some security to the senior counsel of this bar.
not disputed, my lord, but still, my lord,
So how many matters can be passed over?
let it come tomorrow, my lord. This matter can be held up tomorrow. Chairperson, please.
Will you come tomorrow?
Yes, Lordship, can be.
On prayer of the petitioner, the matter is adjourned for the day.
I'm grateful.
Item number 23, WPA 344, after 35.
This matter, Mr. Satish Mishra appears for the respondent authorities. So I'm praying for Passover, item number 23-24.
Passover will not be possible like this, madam. I'm sorry. You are the petitioner in this matter?
No, I'm
Who
not.
is appearing for the petitioner?
Item 23.
Who is appearing for the petitioner?
Probably madam is appearing.
23, anyone for the petitioner? None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench. If the petitioner is not interested, the court cannot hear. For the respondent, the
Respondent.
petitioner is not there. So let it be shifted. Where were you, sir? I was looking for the petitioner. Please delete this one. Yes.
Lordship, he is already having one connection.
Yes. You cannot have a second connection.
My lord, as per the instruction what I got from the petitioner, she's an old lady from Hadbe.
Old ladies, there are exceptions for old ladies.
No, my lord. No, my lord, but she told me that she does not have an electric connection, my lord.
You have documents to support your claim.
Lordship.
Over the
Then-
said land, like, they don't have anything. They don't have.
Consumer number already given, Lordship, in this.
That's a different land together, but she does not have, as per the instruction what I got, they don't have, my lord. Let the department, let the
What
respondent.
is the survey number of the land where you are asking for connection?
It's
Where is it stated?
survey number 188.
Where is it stated? You have a schedule?
It's in the synopsis, page number 3.
Yes.
Page number 25 affidavit, Lordship.
You have referred to the online application, but with respect of
Ah.
survey number 188 measuring in maybe 200 square meter.
No,
Lordship.
if I had already had an electric connection, and if I apply for an online application, then they should reject it, give a remark that I already have the application is still
Yes,
pending.
that has to be done.
Lordship.
Even if you're rejecting it, you need to
Lordship.
inform, isn't it?
So it was not done. So let this.
We will pass a speaking order, Lordship.
ये कौन सा था? ये कुर्बेला में था। 3.
Rejection order is not there.
Rejection order is here. The second page says, isn't it? This
They
is
have-
to be rejected as per departmental rules and policy.
But they have not enclosed it, Lordship.
They've
Along
not
with
it. You've not, have you informed this to them?
Lordship, it is available in portal
Online application.
because they are making online.
Says she's an aged lady, and maybe she has not got access to the portal. Anyway, now that you are before this court, we can deal with this matter.
Lordship,
In this report, where is the survey number?
survey number is not there. Consumer number is there because Tahsildar is not a party to this case.
There is a reference to a letter. Where is that letter?
Lordship, can I go through it?
Please show me. Please see the reference.
Lordship.
Please show me that letter. That will solve the issue.
It is not enclosed. Let it
The same writ petition.
same writ petition.
P44. Writ petition WPA of 2025. Where is the number?
They have not written.
Please see if you have the number in this document.
No, it is not there, Lordship. I am admitting it.
Number is also there.
It has not been mentioned in this
Can you
application.
come back tomorrow with the document? It's a very short issue, can be disposed of.
Lordship, I will, because this is a case of Hadbe, I believe.
Yes.
It is far away. Day after tomorrow, let it be fixed, Lordship.
Soft copy, sir.
Lordship, let it be
No
tomorrow.
place in the world is far away now. You can get soft copies, right?
Let it be, Lordship.
Tomorrow?
Tomorrow.
The grievance of the petitioner is that she has not been granted electricity connection in her residential house in survey number 188, comprising an area of about 200 square meters at Bharati Nagar, Little Andaman, South Andaman district, despite applying for the same before the authority. When was the application made?
It's on 21 March 25. My lord.
Yes.
21st March 25.
On 21st March 2025. Paragraph, letter counsel for the respondents submits that an electricity connection has already been given to the petitioner at the said premises. Learned counsel seeks to submit documents in support of his contention. Paragraph, the matter is adjourned for the day.
Lordship.
The premises number and that connection has been given, right?
I will take the photographs also.
Photographs are
With
not
the
here.
lady.
The documents are required. 21 copies
Lordship.
Item number 24, W359 of 2025.
24, Lordship, just today morning she has served me. Whether she has served the department or not, I do not.
Yes,
because I have to take
affidavit of service. What is the issue about?
grant of electric connection, Lordship. Her application is pending, I believe.
Can you come back with the report day after?
Lordship.
Day after?
Lordship.
The petitioner alleges that despite an application being made to the respondent, electricity connection has not been granted to her in her premises. Paragraph, learned counsel for the respondent seeks to submit a report in this regard. Paragraph, let the matter appear under the same heading on 7th August 2020.
Obliged.
Next.
Item number 25, everything of 2025.
Your lordship, in this matter, my senior Mr. Arvind Prashad appears for the petitioner, your lordship. Affidavit of service already filed with the record, your lordship.
Let. Anyone appearing for the respondent? Anyone virtually? No. No. The affidavit of service. Service. Delivered to- Deputy Varmaji. Whom have you delivered, madam?
Your Lordship,
Who is this Shashi? Deliver, it shows item delivered to Shashi.
she may be, Your Lordship, from.
There cannot be a
office-
maybe, isn't it?
Your Lordship, because I have sent a speed post to the company. And might be he has taken the speed post. I don't know any person by name Shashi.
This shows received by
No,
Shashi,
no.
delivered to Shashi.
Delivered to Shashi.
May not be for the company. We are not sure.
Yeah.
So will you make a further service?
Your Lordship, will make.
Affidavit of service. It appears that service it appears that the arbitration application sent to the respondent has been received by one Shashi, SHASHL. Since it is not clear as to whether it was received on behalf of the respondent, the petitioner is directed to serve a further notice upon the respondent and file affidavit of service on the agenda.
I am obliged.
Paragraph, the matter be placed on the next available circuit bench. Next.
Item number 26.
I'm for the respondent, takes CBI money.
But Mr. Kabir is.
Kabir appears for that, so I'm praying for next circuit, was out of.
He's out of session.
It's out of
Just inform me.
Very good. On prayer of the petitioner, the matter, on prayer of the appellant, the matter be placed before the next available circuit.
Number 27. WPA 270 of 2021.
Yes.
My lord, I have filed an application for amendment of the writ petition, my lord. My learned friend.
What is the amendment? You have received a copy? Yes. You are opposing?
My lord, but my lord, it's from last considerable period it is pending for you. Let it be amended, my lord, what's wrong?
Amendment. What is the amendment source?
My lord, my lord. Just placing it, my lord.
Application regarding the this he is amending the notification of
No, not challenging the notification.
You are appearing for all the respondents?
all the
Yes.
What is the amendment source?
My lord, page number 8, my lord. Certain grounds and prayer, my lord. That notification by an executive fiat, my lord. By an executive fiat, they have curtailed certain rights, my lord. This, initially I filed the writ petition, writ was dismissed, my lord. Dismissed, since at that point of time I was not there, my junior short for time was not given. I challenged it before the division bench and it has been fallen from division bench that you should have challenged this part of the notification. So writ appeal was allowed, my lord. Matter was relegated back to the writ court. Then I taken out this application whereby my prayer, basically I have asked for prayer to challenge the said impugned order, my lord. Impugned notification, which is nothing but an executive fiat, my lord.
What are your original prayers?
My lord, this what happened, my lord? These petitioners are residing in a place where, my lord, due to the rain and all, my lord, a tree, banana tree fallen in their house, as a result of which 3 of the family members succumbed to death. They have allocated compensation of 2 lakh rupees, my lord. This notification. Whereas at the same time, they have allocated much higher amount to other incumbents. So
you have challenged that order?
that notification, yes, only that notification.
Challenge the order
I
actually.
have sought for, yes, my lord, I have challenged that order and I have sought for higher compensation. Now it was fallen from the division bench, you should have challenged this notification also by under the dint of which they have acted.
You have asked for setting aside a part of the impugned notification.
My lord.
So you have to challenge the notification.
No, my lord, that is what we have challenged in this one. Page 9, my lord.
Let this be incorporated. The amendment be allowed. Whether this can be done or not will be decided in the writ petition. Amendment is only for incorporation, right? Whether this amendment can be considered will be decided on merits in the writ petition. Yes. But this is nothing on merits, only an incorporation. This is scan 2 of 2023. The petitioner seeks to incorporate the following prayer.
No, my lord, facts and grounds and prayer, para 11, my lord. Para 11 onwards, it starts, my lord. Schedule of amendment was given. Page 6.
All this was within your knowledge when you filed the writ application.
Yes.
My lord.
All these were.
So
My lord, what happened?
allowing the amendment at this stage?
My lord, what happened, my lord?
I was thinking it's only the prayer. No, a huge lot of facts. Withdraw and file a fresh application.
Then let them file the reply, my lord. I will argue. This scan application, I will argue. Because, my lord, the facts are to be incorporated because I have challenged only I said the compensation which was accorded is less. Therefore, I said that part ought to be set aside. But no, my lord, when they filed.
Petition is of 3 lines.
No, my lord.
The amendment is of 300
No,
lines.
my lord, when they file their affidavit in opposition, when they file their.
Objection to this.
My lord.
Because it would be better, I think.
What happened, my lord, when they filed affidavit in opposition, that time this notification was incorporated. It was not in with my lord.
When the order was passed, the order impugned was passed, which is challenged with the writ application,
No,
you
no.
were aware of the notification.
Yes.
Because the order impugned is on the anvil of the notification.
My lord.
You chose not to ascend it at that time. The order is passed on the basis of that notification, for which you have challenged the notification, right?
But the notification was not with
This
me,
is
my
not,
lord. Page 39. No, इसमें नहीं है.
You are aware of the.
No, that notification, my lord, the part is incorporated in the order that this notification. Notification, but I don't have the access of the notification, my
What you
lord.
can do is you can withdraw and file a fresh writ petition on the same cause of action.
My lord, let it be, my lord. Let my learned friend file reply. I will try to pursue, my lord.
Very good. You want to come back with an objection? Not necessary.
Not necessarily, my lord, can decide this.
Actually, it can be decided even
Yes,
without an objection.
without accepting this.
Very well, on your prayer, I will shift it to the next set. On prayer of the petitioner, the matter be placed before the next available set. Next.
My lord, I may be permitted to mention item number 25, my lord. Service is already affected, my lord. It is subsidiary of Tata company, my lord. The respondent.
Who is she, that person? Who is that?
The
person?
staff of the company.
How do I know
My
that
lord,
she
it is a
staff?
speed post, my lord. It was not served by
That's
me.
said, serve a further notice to the company and come back.
Next,
The company says we are not informed. We do not know who this Shashi is. We have nothing to do. It's an arbitration proceeding.
only appointment of arbitrator.
Maybe it should be in presence of the other side.
If they are not coming, my lord.
Serve notice. Next.
Item 38, WPA 177 of 2022.
This matter.
I don't kindly see the order, my lord, passed in previous occasions. Keep on dragging the matter. If they're not interested, let it
You're
get dismissed.
first.
My lord.
Tomorrow this matter can be disposed of. Since my senior is conducted before court number 2 tomorrow.
It was fixed on Friday, my lord, upon their prayer. My lord, the civil suit is pending between the private respondents. I have filed a civil suit. I have obtained an order of status quo. They also made their appearance, and after that they have come up for this writ petition, seeking direction upon the Tehsildar to culminate the RC case which was generated, UR's case, my lord, which was generated in the year 2001.
And the issue in the civil suit is the same.
It's entirely different, my lord.
It's entirely different.
Entirely.
So what is the difficulty in culminating this proceeding, concluding this proceeding?
Actually, my lord, a report was called for from the Tehsildar official respondent. They have filed their affidavit stating the fact that no such document is lying with the revenue authority. And after 20 years, he has come up for this.
It's appearing for the official respondent.
My brother is appearing.
Thereafter, subsequent complaint was filed. We have initiated RC and findings was there that footpath with regard to that has been already been decided. My lord. So this court.
But here I find the prayer is only for
Under 2001.
concluding the proceeding, the pending
It is of
proceeding.
2001, my lord, and they have come up with the writ petition in 2021.
My lord, it is not related to the petitioner, my lord. So far as I can apprise the court, if my lord you see the copied bottom part, it is Neela Ray, my lord, because the present petitioner is Neela Rani Banerjee. So this proceedings, we have already submitted a report to the court that no such proceeding, the records are not
Pending.
not traceable, my lord. Subsequently, based on the same allegation, a proceeding has been initiated and order has been passed based on the same allegations. But this is with regard to some Neela Ray, my lord, not the present petitioner.
We have taken exception to that report of the deputy commissioner also.
They can show that any document.
Difficulty is, my lord, because of this writ petition, they are not even filing the WS written statement before the trial court.
So Japan is here.
So now a suit is pending.
Yes.
I'm yet to file my reply, written statement. Because time was extended by the trial court. The issue which I have raised in the present writ petition can be taken into account by the in a civil court also, Lordship. My claim is, Lordship, my property has been occupied by the private respondent. They have set a proceeding against me. Certain orders were passed. So far as the present proceeding is concerned, the complaint which I have lodged, which culminated in passing a stay order, was not given effect to. The proceeding is still pending. So now,
So you're not pressing this application?
Lordship,
That
since
is.
the suit is pending, it's the issue which I have raised.
You are not pressing this and all your issues will be raised before
The issue which I have raised here, I have maybe granted permission to raise all these issues.
Yes.
My lord.
Let that be done, let this
My lord,
be pressed. It is submitted on behalf of the parties that a civil suit pertaining to the issue in the present application is pending. The petitioner seeks to withdraw the writ petition with liberty to place the contention of the present writ application before the civil court. Such liberty is granted.
I'm great.
I'm great. The writ petition is dismissed as not placed.
Obligement.
My lord, item number 21 is directed to taken up at 1:30.
Yes. Are you ready?
Yes, my lord, maybe call out. My counsels are there.
Yes. You are appearing for the petitioner?
Yes, my lord.
Yes, my lord. I appear for the petitioner, my lord. I appear, my lord. It's an order, my lord, passed by the learned arbitrator, my lord, by which, my lord, statement of claim was taken on record. My lord, it's a challenge to, my lord, the arbitrator's order, my lord, where, my lord, courts have held only procedural directions, my lord, can be challenged. This is a procedural direction, my lord. My lord, the default had already come into operation, my lord, because he had not filed the statement of claim within the period. That's section 25 of the act in question. My lord, judgments were relied upon by, my lord, us.
I am for the respondent.
My lord, without prejudice, I'll be making my learned friend will make a point of, try to make a point of. He passed a direction, my lord. We are in court. My lord, without prejudice to your rights and contention in the revision, we filed it. Otherwise, it will be ex parte against me, my lord. We filed the SOD, my lord. But, my lord, if your lordship takes section 25 of the Arbitration Conciliation Act, which provides for default, it doesn't say, my lord, any final warning has to be given. And, my lord, the authority... I'm sorry, my lord. I'm very sorry.
Before you proceed further, We just have 2 more days to go. So this will take some time. I would like to shift it to the next circuit.
Whatever Lordship says, my lord. It will take some time, my lord. Its Lordship is absolutely correct.
From
Keeps
the
it.
submission, I can make out that it will take some time.
Yes, absolutely, absolutely, my lord. And I'm very sorry, my lord. That day, my lord, I had to take a flight. I appeared from the car. I apologize.
Oh, you were there, right?
Yes, I am very sorry. I apologize. I shouldn't have, but I have my flight was below preponed. Below that's created the problem.
Great.
I'm very sorry. Great.
On by consent of the parties. The matter be placed before the next.
Grateful. Great.
Grateful, my lord. Obliged, my lord.
Yes.
Number 29.
Hello.
23.
Attention, bhoge.
Betty, my lord, I am appealing for the petitioner. I have filed a CAN application. They were given time. 29, I am appealing.
In both the matters.
My lord. They have to file the opposition to the CAN application.
Who is appearing? Have you
Mr.
served?
Tulsi Lal was, no, my lord, it's a pending matter. Yes, my lord. Even Mr. Rakesh is
Shifted to the next benches circuits.
on his prayer only. Mr. Rakesh is also appearing for some of the respondent.
None appears for the respondents.
But Mr. Rakesh appears generally for the administration. However, in this matter, administration have a very limited role, my lord. The main role is of Mr. Lal, my lord, who appears for the district judiciary, my lord.
Mr. Lal is for respondent number
The respondent number, I am just placing
5.
5.
The district judge.
My lord,
district judge.
my lord.
None appears for the 5th respondent. The matter be placed before the next available circuit. Matters be placed. There are 2 matters.
My lord, I think there is a direction upon them to file the affidavit in opposition. My lord, my lord, my lord.
Number 31. Number 6. 8 of 23.
Yes. Served?
My lord, affidavits are complete.
Oh. In that case, I don't think I should take up the matter. It should be a lengthy hearing.
Yes. Small issues, whether.
No, it will take time, my lord.
No, my lord. It will not take much time, my lord. It will not take much time.
All that appears small is not really small only.
But this is with regard to, my lord, illegal construction done by the private respondent, my lord. Yeah, my lord.
My lord,
Because on
I'm just seeking, just not today, because my lord, my 2 files are, my clerk perhaps taken the 2 files, my lord. There are total 4 files.
Not today takes us to the next circuit. I'll not be taken.
देखो ना दूसरा 2 फाइल लेके चलेंगे.
point and
From tomorrow hearing matters cannot be taken.
Fine.
Learned counsel, you're the private respondent, right?
I am for the private.
I am for the respondent number 1.
Learned counsel for the.
इस सही मेरे 2 फाइल लेके चले.
The next evidence.
नहीं सही क्यों बोलता?
Next.
Number 32. WK 9 and 2 of 23.
I am for the respondent, my lord.
Shall I? No one.
Japan.
Japanese.
Yes.
Yes.
Takes time, your lordship. There are numbers of litigations.
One after the other. Reports, adverse reports were prepared, overlapping one another. It will take time.
Not in a mood.
It's not like that.
He's unwell.
It's not like that.
Unwell.
On prayer of the parties.
Individual.
The matter be placed before the next evidence.
Obliged, my lord.
Item number 33. WPSC. Number of 24.
Respondents?
Lord, I'm appearing to the respondents. My lord.
You filed your reply?
Lord, I filed my reply. Lord, I checked the record also because we say that the N factor was introduced in terms of CPW manual because the provision given. That's
You have used an affidavit, a supplementary affidavit in this.
yes, Lord, they given supplement.
Check. They have decided 11 disciplinary ban. Can they do it? This is the point. And they come to that, you should have an opposition.
Have you received the copy of the
Supplementary I have received.
supplementary affidavit?
Yes.
Do you want to use a reply to that?
Lord, I just give a reply. I will enclose the provision Malad, under if what is the CPW manual so that it can be clarified the court whether we have a powers to amend or not.
You need to come back with an affidavit.
Yes, Malad, that will be.
Let him use a reply. You are the respondents. The respondents
Yes.
seek to use a reply to the affidavit filed by the petitioner annexing relevant documents. The matter be placed before the next available circuit bench. Petitioner will make it supplementary to the supplementary affidavit filed by the petitioner.
My lord, yesterday, Ms. Nag had given us a copy of that computation of interest for delay. My
Yes.
lord, the PBMC stand, my lord, is reflected in a note, my lord. Mr. Rakesh will just hand over a copy of the same. Our stand.
Mr. Rakesh, does-
But they sent me through WhatsApp. I told them to bring it, but they're not bring it.
It's a single page. If my lord permits, then the court officer can take a print. It's just a one page, my lord.
Whatever it is.
that is what I had said, that let both the parties come back with their calculations so that we can tally
A
them.
copy of that can be fixed tomorrow and the matter can be disposed of. Because it is only.
No, actually, my lord, they have not given any calculation, my lord. They have only stated, my lord, that they have given the dates when the payments were released and the reasoning why there was delay. That is all. They have not really responded to the calculation, my lord. If that is to be looked into, my lord, then it can be, my lord, adjourned to the next circuit, my lord.
Why? What is the requirement? Your worship, I have given.
They have not stated anything on the calculation, my lord. They have not been able to give that instruction, whether the calculation is correct or not. They are saying, my lord, that the provisional pension order, my lord, was dated 14 July 23.
You can make submission. Your worship, may
Next
kindly.
circuit, this will take time.
I have
Because they have
given
come
the.
back with their calculations and that has to be tallied because there will be objections. Mutual objections. So
My lord.
this is being submitted to them.
Let it be observed, your lordship, that they want to submit their own calculation.
Yes.
Let it be submitted.
A document indicating calculation of interest filed by the petitioner is taken on record. Paragraph, the respondents seek to
एक गलती तुम करिए और
submit their stand
पूरा चार्ट
on such computation of interest.
दूसरे भी लिखना चाहिए.
Paragraph, please for the next available circuit.
My lord.
Please serve an advance copy
Yes,
to
yes, ma'am.
Ms. Nak so that
I will
she's
serve.
able to go through it.
Yes, ma'am. Obliged.
My lord.
Item number 35. Agency 4 of 925.
Yes.
I give for the respondent of 3 years.
My lord, I am appearing on behalf of the added respondent, my lord.
Yes.
I have already filed my affidavit submitting report, my lord. I was asked to submit a report. The last order.
Affidavits
My
are
lord, please.
complete.
Subsequently, 2 respondents have been arraigned.
An opposition was called for.
My lord, may kindly the last order, my lord. Order dated July 4,
You are for
2025.
the Tehsildar, Deputy Commissioner and Tehsildar.
My lord.
Yes, a report was called for.
Yes, my lord. So I filed my report, my lord. It is on record.
This is 2 and 3.
मेरे ही है। उनको भी दे देगी एक ही कॉपी रेडी की है।
You received a copy.
With the understanding, those madam is saying that she has no photostat copy, extra copy.
No, I can give it to the petition. Please.
I'll take an exception to it.
An opposition has also been filed by whom?
Opposition has been filed.
Original respondent.
Original response.
The eviction officer. You are the eviction officer, right?
Yes. Okay.
So you have a copy of this. You need to come back with a reply to this.
Yes.
Affidavit in opposition filed by the original respondent and affidavit submitted by respondent numbers 2 and 3 have not been added somehow.
Yes. Yes, my
In
lord,
the
on
cost
the
of-
July, if my lord sees the July 9th order, my lord,
Order is there, but I have corrected nothing.
Right, right.
and we have received the notice also thereafter, we have
2 and 3. Affidavit submitted by respondents 2 and 3 are taken on record. Paragraph on prayer of the petitioner, liberty is granted to use exceptions to both the affidavits. Exception that use reply / exception to both the affidavits. Paragraph, the matter be placed before the next available circuit.
8 copies for the regulation.
Next.
Item 36,
Obli-
7 of 125.
On prayer of the appellant, the matter be placed before the next available circuit.
Item 37, W3 and 209.
Well, I am for the official response.
Reply to the opposition.
You are for the
Respondent number 3.
private respondent. You have the opposition copy? No, nothing.
We have got the opposition. We have got the opposition. I have the opposition.
The official respondents don't need to file an
Lord,
opposition.
it is
right?
with regard to the violation of the unauthorized portion of the building in question. So far as we have issued the final demolition order, it was placed before the chairman for approval. This is the stand we have clarified.
Where have you clarified that?
No, my lord, we have made a submission before the court that this is our position. They want us to implement, the petitioner want us to implement the order of demolition.
Any commission, I do not have a research.
Because they are asking for execution of the demolition order. That is your
That
prayer.
is the
Yes.
Have you challenged this order?
Yes.
Demolition order?
That was been appealed, the appeal has been before my lord. The date is also fixed. Sorry.
After 7 years, related appeal.
Yeah, my lord.
Has it been admitted?
No. Section 5 is still pending. After I filed the writ.
My lord.
The appeal was preferred.
Yes.
No, Melody will not be the Let my senior come and make.
Let Anjali madam.
On prayer of the private respondent, the matter is adjourned for the day. Please put these matters under motion heading because hearing matter. যেগুলো urgent for the day I'm doing now, সেগুলো please under heading motion. Do not fix any hearing. Next.
Item 38, W3 1 of 125.
My lord, I am seeking extension of time to file my.
Reply.
My lord.
The learned counsel for the petitioner seeks extension of time to use the affidavit in reply as sought. Paragraph, the matter be placed before the next available circuit bench.
My lord.
Afterward matter. Item number 11, W3 3 of 2025.
It's
Page 51.
You are challenging this order. How could this have been passed without the final decree being passed?
Yes, Lordship.
Final decree has not been passed.
May I say one thing? The preliminary decree affects the rights of the parties. Final decree is
Subject to the final decree.
simply it's a ministerial work. No, partition commissioner would submit the report, final decree would be drawn. In terms of regulation 85, rights are affected in terms of what would happen even the final decree is passed. The Tahsildar has to do the same thing, what has been done in the preliminary decree. He would simply record the name of the parties, all the parties.
Why will the Tahsildar do it? The court will do it. The court will give directions. Where is the preliminary decree from?
Start from page 18.
Court cannot do it.
The operative part?
My lord, page 47. 46. Last part. 46. Last paragraph. Parties are at liberty.
That's right. That is so law. Every preliminary decree contains this condition. Even after the final decree has been drawn up, Lordship, the mutation is to be done in terms of preliminary decree, Lordship. That is my point.
There is a specific direction, failing which the parties shall have the liberty to divide and possess their shares in the suit property by metes and bounds in accordance with law. So that will be by order of the court.
No, but the mutation has to be
Commissioner has to be appointed.
Mutation comes later on.
Lordship, no, I have not got the judgment of this Lordship Honorable Justice Sanjeev Banerjee up to the point because there are big files in my chamber I could not get hold. I was in petition there. I lost before the writ court. Division bench presided by His Lordship Honorable Justice Amit Talukdar and Justice Sanjeev Banerjee. Honorable Justice Sanjeev Banerjee wrote the judgment. Lordship, up to the point. Based on the preliminary decree, rights are affected. The Tahsildar had to do the mutation in terms of preliminary. That judgment I could not get hold of. It's an old one because when I started my practice, 2002, that period of it will take time. Up to the point. Yesterday also I made the same submission because I'm having that. I'm equipped with those judgments. I could have not even if
Next circuit, but I'll not stay.
I'm not praying for statements. Not praying for statements.
Next circuit.
There's no scope of anything.
On prayer of the petitioner, the matter be placed before the next available
Hundred.
circuit.